From Massachusetts, this court is open. Please be seated.
Morning, everyone. My name is Vicki Henry, and I'll be your panel chief today. To my right, we have Justice Shin, and to my left, we have Justice Chris Hodgens. If you have not been here before, I'll let you know that each side has 15 minutes. For better or for worse, we do not have rebuttal in the appeals court. Today is February 6th, and I'm going to call the first case, which is 2022-P-0843, Commonwealth versus GASQUE.
Good morning, Your Honor. Suzanne Renaud for Aaron GASQUE. He does pronounce it GASQUE. GASQUE.
GASQUE.
Yes, Your Honor.
Thank you.
So this case actually, I believe, had a host of problems, and it comes down to, I think, one pretty basic point, which is the law is what the legislature says it is. It's not what the ADA says. It's not what the chemist says. It's not what the expert witness or the recipient witnesses say. It's what the legislature say. And in this case, for better or for worse, the legislature has said that MDMA form of methamphetamine is not the same as other forms of methamphetamine under Section C2, either salts or their isomers. It's not.
So I want to make sure I'm understanding. Your argument is that, yes, MDMA has methamphetamine in it, but in a particular chemical formula, and the Commonwealth has put it under a particular statute and subsection.
That appears to be what is the case here, Your Honor. And the reason I say that, and I just want to just loop back on this, under the federal regulations, MDMA is treated as an hallucinogen, and other forms of methamphetamines are treated as stimulants. And so that would be one of the explanations for the difference here. What happened, or appears to have happened in this case, and I obviously wasn't there, but I am reading the record, is up until 2021, this substance, these pills that we're talking about, were consistently called MDMA or ecstasy, which falls under Section A8. And that was in the grand jury minutes over and over and over again. There is not one place in the grand jury minutes where they call it just straight on methamphetamine. It's the same officer.
I don't know. I think the grand jury minutes are somewhat ambiguous in how the charges are lining up, because when a juror asked about the weight of the bag of pills, and the Commonwealth's response was that the weight is relevant to the trafficking of methamphetamine, which suggests to me that they were treating the pills as methamphetamine.
Your Honor, it was, I believe that the statement was they are relevant to distribution, not to trafficking. And I could go back and double check that.
All right. Well, by 2021, it seems pretty clear that they're treating everything as methamphetamine, right? Because the only way you get to the amount, 200 grams, is if you add everything together, right?
Which would be a whole different issue we would be talking about here if the 2021 indictment stood, but the judge dismissed that. Or under a motion for required finding. We are not dealing with that.
I think where I'm struggling is the law might be what the legislature says it is, but the evidence is what the evidence is. And it seems to me that you framed it as a sufficiency question. And on that element of the offense, it seems that the chemist's testimony is what matters.
Well, okay, Your Honor. Let's assume that the chemist's testimony takes the day here as opposed to any of the other witnesses, which obviously you can use lay witness testimony. But that only tells you what the substance is. It doesn't tell you about the distribution portion of a trafficking offense. And on the distribution, they brought in a distribution expert who was extremely clear in this case that methamphetamine, under C2, would be in crystal form, it would be addictive, that you would break off a little piece of it, and that is how that would be distributed. On top of which, that conforms with the 2019.
He said that the pills in the aggregate, that's consistent with distribution.
But what he said, Your Honor, it's still consistent with distribution, but we don't have count 3 of the 2019.
No, but I mean, we're operating under the assumption that the chemist's testimony, we accept that at face value, that the pills are not MDMA, they're methamphetamine. We accept that.
Well, I don't accept that, but I'll take that for purposes of the question.
I don't know how on this record we can say that the pills were in fact MDMA. We have nothing in this record where we can conclude that. So if we accept that the pills were methamphetamine, And the distribution expert testified that the pills in the aggregate are consistent with distribution.
But he didn't
Why isn't
say that
sufficient?
methamphetamine is distributed as a pill. He said MDMA or ecstasy, which he furthermore defined as a methamphetamine derivative that's combined with other substances, and incidentally, this had caffeine in it. And then he said MDMA is distributed in pill form, and MDMA is distributed as a party drug, and MDMA has hallucinogen love drug effects. MDMA is distributed this way, over and over and over again. That's how he described that. So as a sufficiency issue, so accepting for this purpose that the chemist, who arguably should be treating these under a different way, but she treated them all as methamphetamine, and it's going to spark that. Because I would say that even in the grand jury minutes, the officer who was there said that he used a field test of a methamphetamine, some sort of methamphetamine and MDMA, so it sounds like they have a relationship. But even accepting that, once you get to the distribution part of this, according to the expert, methamphetamine, C3, crystal methamphetamine, is distributed as a rock. MDMA, he said, which is a different legal substance, it's a different legal substance in Massachusetts. MDMA, he said, is distributed in pill form. And so you cannot have both those things be true. And so what that basically means is there is a failure of proof here from the Commonwealth of proving that this is methamphetamine that is trafficked. Maybe that would be, for your purposes or for these purposes, that would be possession of methamphetamine, but that is not distribution or possession with intent to distribute, and it is not trafficking of that substance.
Let me ask you this. But even if we were to agree with, generally with what you're saying, if the presentation here was not crystal clear by the Commonwealth, the question is one of sufficiency of evidence. And we have what's, I would say, is somewhat unusual. A verdict slip spells out for the jury exactly what the evidence is. Trafficking in methamphetamine, 18 to 36 grams, allegedly found at the bottom of the stairs. That's kind of a unique verdict slip. So if there was any question, as you're pointing out, in the presentation of the evidence, the verdict slip makes it clear to the jury that they are not to return a guilty verdict unless it is methamphetamine found at the bottom of the stairs. So doesn't that tend to resolve all the issues here?
It resolves nothing, Your Honor, because what we have here is that fancy problem and other problems here, like from Barboza. What does the petite jury even think that they're ruling on here? Because they are being told that count one is methamphetamine. If you look at the grand jury minutes, it is. I don't think that that's ambiguous. If it is ambiguous, then you have a Smith and Barboza problem. But if it's not ambiguous, count one was very clearly the crystal, and then count three was the MDMA pills, which they later on called methamphetamine. So you automatically, my apologies, have a problem here that count one never should have been listed as the substance at the bottom of the stairs, because that is not consistent with what the grand jury heard. But then, if the petite jury is thinking that, if they do in fact believe this is MDMA, which is not the same thing as methamphetamine, because they were told that repeatedly and not incidentally during the course of this trial, that is not the type of substance that can be trafficked. So that's another problem right there. And then on top of it, if they do believe that pills that the pills that were there are in fact methamphetamine as a sufficiency issue, they cannot believe it was trafficked because they were told by the only person there, the distribution expert, that methamphetamine is distributed as a crystal and MDMA, which is a separate legal substance, is distributed in pill form. There's just problem after problem after problem because of all of this ambiguity. The petite jury doesn't have any indication really of what they are ruling on. It's not consistent with what the grand jury got. It's not consistent with the legal standards that are here in Massachusetts. And the 2019 grand jury indictments are inconsistent with the 2021 grand jury indictments. This is a problem on multiple levels, Your Honor, and unfortunately, Mr. GASQUE is sitting in prison because of this, of being found to traffic something that cannot be trafficked.
So this is, I'm going to go back to the question I started with. If MDMA has methamphetamine in it, does the Commonwealth then have the option to proceed under something that's not MDMA because it has methamphetamine?
They do not, Your Honor, because under C2, it says as long that methamphetamine is considered a salt or an isomer as long as it is not listed under any other schedule. MDMA is in fact listed under a different schedule. It's listed under A8. It has, if you look on the regulations, which I cited to, and I'm sorry I don't have them, but also relates back to the federal regulations. Those are under two different schedules because MDMA is an hallucinogen and the other one is, other forms are considered to be stimulants. Now, California...
If we were to have a simpler case that had less drugs in it, right, and we only had MDMA at the bottom of the stairs, and the Commonwealth indicted under C2 or C3, you would say that it has to be a not guilty required finding as a matter of law because it's MDMA.
So, Your Honor, yes. So let's say this, for example, the judge here, instead of sending this to the jury on count 1 of the 2019 indictment, sent it as a lesser included of the 2021 indictments, for example. I mean, that might make a little more sense because then you don't at least have the problem of it not being consistent with what the grand jury heard. I would be making very similar arguments here because I would say their distribution expert said that methamphetamines are distributed in a different way. So even if that were a substance that wasn't I'm sorry, the language is something 8, methamphetamine, I don't even know what the words are. Even if the chemist hadn't said that, the problem would remain that when you are told, for trafficking, you have to prove distribution. When you are told that the thing that is being distributed is, in fact, MDMA, the jury in no way can find trafficking.
That's not what he said. He was presented with the pills, right? Whatever the chemical composition of the pills are, he was presented with the pills. And he was asked, looking at the pills on the aggregate, is that consistent with distribution? He said yes. So if we accept the chemist's testimony that the chemical composition of the pills was methamphetamine, not MDMA, then why is that not sufficient for distribution?
Because the distribution expert, and I think I'm following your question, he did not say these two substances were the same. He was the one person who said to the jury, as a person with expertise, that MDMA, the compound, is different from methamphetamine. And then on page 28, he says, okay, the pills to the right of the marijuana, what is that? That appears to be MDMA. Okay, and then he says those are ecstasy pills. This is as he's explaining distribution. Okay, and then the question from the prosecutor is, okay, what amount of MDMA or ecstasy methamphetamine, keeping in mind that this expert just said that MDMA methamphetamine is different than the other kinds, what does that indicate to you? He said, again, looking at it, 50 to 100 pills.
What is ecstasy methamphetamine?
He called it something different, Your Honor. He said it was a compound.
Ecstasy methamphetamine? Is that the same thing as MDMA methamphetamine
I think
or
it's
not?
pretty clear that on this record, from the way this officer was talking.
He's not qualified to say what the pills, what the chemical composition of the pills are, right?
Your Honor, I believe there is the case is Dawson, and this court has said that I believe that's the case, that police officers can, in fact, opine on what the substance of certain compounds are. There has been lay witness or non-expert witness testimony has been in fact allowed on.
So he can testify that these pills are purely MDMA and no other non-MDMA form of methamphetamine. You think he's qualified to testify?
Your Honor,
that?
the courts have said he's qualified, which means that the jury are getting conflicting information.
How could he testify that these pills don't have any non-MDMA methamphetamine? What possible basis would he have to testify as to that?
Your Honor, you're maybe putting the cart before the horse. You're saying non-MDMA form. You're saying the problem here is if he is saying that that there is methamphetamine in here, and that's what the chemist said, she did not preclude it from being an MDMA form of that. She didn't provide enough specificity. This may be a problem with the way the chemists are working, but I just want to
Right,
point.
and maybe, you know, these pills can be tested, and it's discovered that, in fact, they are purely just MDMA, but on this record, I don't know how we could conclude that they're.
Well, Your Honor, taking that as the principle, I still maintain, based on everything that distribution expert said, he did not establish that these were distributed the way that methamphetamine would be. In my final 30 seconds, if I just may go to the possession issue, especially with relation to the bottom of the stairs. There's no indication that they were thrown there. He doesn't live there. The timing is 45 seconds from the top to bottom. The officers, the SWAT team is there at the door when he's there. I would just say, when did he even have the opportunity to go that 15 feet so that he could throw things on the bottom of the stairs in an area that the distribution expert said was consistent with being an area that, the way he described it, as a stash area? I would just say that the evidence fails on possession as well. If there are no further questions, I would rest on the remainder of my brief. Thank you.
Thank you. We'll hear from ADA Thomas.
Good morning, Your Honors. Matthew Thomas for the Commonwealth. I represented the Commonwealth at trial and also at grand jury as well. The case is clear that the defendant was indicted for methamphetamine, he was prosecuted for methamphetamine, he was convicted of methamphetamine. I can understand the nuance that was introduced in this case. It was introduced in part, though, by defense counsel in opening when he said that MDMA, methamphetamine, ecstasy, it's all the same thing. That was the phrase.
She's listed out how many witnesses who said that MDMA and methamphetamine are the same thing.
And part of that comes from that first grand jury presentation. And the case is unique in part due to the COVID emergency. There was a delay in getting the drug analysis back. There were two grand jury presentations. One that was pre-analysis, and that was when the term MDMA was first being bandied about. It was what officers were relying on or arrived at after visually inspecting the narcotics that were discovered. The second presentation was after the drug analysis was performed, and we had the forensic analysis of the chemical composition of the narcotics that were in the field of play.
So if you test MDMA against a methamphetamine exemplar, would it come back positive every time?
Well, that's a question that should have been put to the expert during the presentation of the case. She testified that it was tested against a known methamphetamine and came back as methamphetamine.
MDMA has methamphetamine in it, right?
Yes,
so
Your
would
Honor.
it always come back positive if you tested it?
I do not know.
Or you didn't expect chemistry questions at your oral argument, but if you have something that for all intents and purposes looks like MDMA, is the practice to test it against both methamphetamine and an MDMA exemplar, or is it only tested against methamphetamine?
Again, it's a difficult question for me to answer, as I don't know how the chemical composition of MDMA would stack up against the known. I don't know what the known, I know from the record it was described somewhat summarily as a methamphetamine standard, and it tested positive against that.
Would you agree that if, in fact, these pills were MDMA and did not contain any non-MDMA methamphetamine, that he could not have been convicted under this statute?
You know, I would like to see I would like to have a hearing with the expert to see exactly.
Just as a matter of statutory construction, if these pills
yes.
were purely MDMA form of methamphetamine, do you agree that he could not have been convicted for trafficking methamphetamine? He'd have to be tried under the statute specific to MDMA?
Yes.
Okay.
I'm not sure what the forensic analysis would entail to differentiate an MDMA pill from a pill that is methamphetamine. Part of the problem, I think, is the distribution expert in this case, looked down and saw the pills, and he did not have the benefit of a forensic lab when trying to classify those pills. In speaking about them, the officers on scene did not have the benefit of a forensic lab. That's why the value.
Where you agree that if these were MDMA, well, that MDMA would have methamphetamine in them, and if these pills were MDMA, that someone should have asked the expert about both tests, and the Commonwealth bears the burden of proof. How can we conclude there was sufficient proof here?
Well, because the analyst, the forensic analyst for the Commonwealth, was clear in her testimony that she tested them as methamphetamine, because what's important about it, and what it came in as an exhibit was...
But wouldn't MDMA always test positive as methamphetamine? It has methamphetamine in it.
From the record, we know that the expert had noticed that it was potentially MDMA rather, because on the property tag, when the officers were working on scene, they described the pills as being MDMA on the property tag. So the forensic expert did have noticed that the substance did exist or potentially existed as MDMA, but they came back as methamphetamine. So I think the record is clear that
Right,
it's
but
not
at the beginning of your argument, you agreed that MDMA has methamphetamine in it, so it would always come back positive. And then the Commonwealth wouldn't have properly explained to the jury which statute applies.
Well, again, arguing in a vacuum, I'm not sure if those, chemically, I presume those other additives would also appear during a forensic analysis.
I don't know that we can presume that.
Well, we know from the work that the forensic analyst did, and she inferentially tried to differentiate it from MDMA because she had noticed that it was potentially MDMA, but did not opine that it was.
Why do you say she had noticed that it was potentially MDMA?
Because she identified the property tag as what she used to identify the pills at the bottom of the stairs as the pills she was working with, both in the forensic work and during her testimony.
So was that put in as the truth of the matter asserted, that it was MDMA?
Well, I was using it to link up for chain of custody authenticity purposes, from an evidence point of view. It was not the property tag, certainly, that described what the chemical composition of the substance is, but it speaks to...
Right, but it raises the question of whether this was MDMA as opposed to a different kind of methamphetamine that, for the legislature in their wisdom, put under a different statute. It could have put it all under the same statute, but it chose not to.
And so one presumes, and again, I think it's a fair presumption from the evidence that if this MDMA is an issue in this case, as it was earlier described in the narratives and in the property tags, that the forensic analyst would have been sensitive to it when she did her work, knowing that
But we don't know that, and the Commonwealth had the burden of proof on that issue, right?
The Commonwealth had the burden of proof that it was methamphetamine, and we sustained it each step of the way. I would ask the court to look at the operative documents in this case, whether it's the indictment, the verdict slip, the analysis. It's methamphetamine consistently. It's not until the defense raises MDMA that this issue is raised.
Did you agree that if MDMA is tested for methamphetamine, it would come back positive? Or did you, I'm just trying to clarify your response to that question.
Well, I am assuming that it would because of the chemical composition of the substance. But I don't know. I also assume, without knowing, for what that's worth, that there would be these other additives that also reveal themselves when tested against a known methamphetamine.
Well, let's put it to you a different way. Let's assume, just for the sake of argument, that the Commonwealth, that the legislature said, okay, caffeine plus aspirin is going to be prosecuted under Section 1, and just caffeine is going to be prosecuted under Section 2. And the chemist tests whatever's found by the police, and it has caffeine. That doesn't mean it's got caffeine and aspirin. All that you've established at that point is that it has caffeine, right?
Yes, Your Honor.
Or let's say it's aspirin and caffeine and salt and caffeine, and you test and it comes positive for caffeine. We still don't know which statute you're under, right? Because we don't know what else was in there.
Yes, Your Honor.
If the chemist doesn't tell us, we don't know, right?
Yes, Your Honor. But what we know that what we don't know from the record is how MDMA appears chemically when it is analyzed by the forensic specialist. But we do know that the chemist was aware that MDMA was a possibility, and we can presume, and she was asked what kind of test she used to analyze that substance. And if I remember correctly,
Do you have a case that says we can presume that?
I do not.
Okay, because the statute says it's under this statute unless it's listed somewhere else. So don't you have to prove it's not listed somewhere else? Didn't you have to prove it was not MDMA if they both had methamphetamine in them?
Well, I think we did that through the chemist's testimony. And in describing the test that she did, it'd be one thing if it was a visual inspection of the pills and saying that the pills line up with a certain visual characteristics of other pills of this manufacturer. But she didn't. She ran the gas spectrometer test. Excuse me, I know I mangled that, but she ran that test and she found the exact chemical composition of that tablet, and she opined that it was methamphetamine.
So, go ahead.
Can the pills contain two different forms of methamphetamine? I mean, how sensitive are these spectrometry tests that they're doing in these labs? Do they test for specific forms of methamphetamine?
Your Honor, that is a question I do not know the answer to.
Can there be theoretically two different types of methamphetamine in a pill?
Again, Your Honor,
Okay.
We've reached the boundary of my knowledge of chemical science. But,
Right.
but methamphetamine, I believe, has a specific chemical composition.
So your opposing counsel argues that a Dawson case allows police officers to sometimes, in some circumstances, testify as to what a substance is. What do you say to that?
Well, I think it's easier when it's marijuana or a narcotic that's more easily visibly identifiable. But a case such as this, when it's a bare pill and a pill of illicit manufacture, an officer working on scene, as they did here, can only rely on training and experience. Obviously, I think they got it wrong when they described it as MDMA when they were filling out the property tag, which is why the Commonwealth called our chemist as the forensic expert on the chemical composition of these pills. So, but I don't think the officer or even the jury had a problem with the marijuana in this case.
Do you know how many witnesses testified that MDMA and methamphetamine are the same thing?
If anything, I think it was really our distribution expert that muddied the water the most. Other than that, it was, I think, defense counsel in his opening argument that said MDA and methamphetamine and ecstasy were the same thing.
All right, well, we're going to leave that aside from you can pick whichever answer you want, I don't care, but are MDMA and methamphetamine the same thing?
Under the statutes, no.
Okay.
Can the jurors take, can they credit some of the testimony of the police officer and some of the testimony of the chemist? In other words, they're not bound to accept the entirety of someone's testimony. Is that true?
That is true, Your Honor, and they were so instructed.
And was there any jury instruction relative to MDMA?
Not to my memory, no. But they were given the standard and approved expert testimony instruction.
So how many, besides MDMA, how many other methamphetamine compounds are listed in another schedule in the statute?
It's a list, Your Honor.
Are there many?
I know there's methamphetamine somewhat generically, and there's MDMA. There are others that
That are listed separately in a different schedule?
I believe there are, Your Honor.
Okay.
So where this issue has been raised about what it is the chemist did or didn't testify to, do you think the Commonwealth has any burden at this point to find out whether the chemist in fact meant that this was not MDMA?
No, that's an interesting question, Your Honor.
Well, someone's sitting in prison,
Yes,
and the
Your Honor.
Commonwealth has the burden of proof on this issue.
No, and it was in response to the chemist's work that the Commonwealth went back into grand jury for a second presentation. I mean, when we had what we thought was the final answer from the chemist, we went back into grand jury to try and get the right answer, the just answer, to address Your Honor's concern.
Did the chemist ever testify this is not MDMA, this is not something that's not in a different schedule?
To my knowledge, no, Your Honor.
Would the chemist be able, how would the chemist be able to testify to that? Would she have had to test the pills for every other compound listed in a separate schedule? I mean, how does this work?
As I remember the testimony, the spectrometer works with the analysis of the substance. The chemist then, somewhat subjectively, tries to match the peaks and valleys of the substance that's being analyzed to what the known is. And I believe, if memory serves, she tested it against the known for methamphetamine. Whether or not the chemical profile of MDMA dramatically differs from methamphetamine, I don't know. But what we do know from her testimony is that it was consistent with the substance for which Mr. GASQUE was indicted.
So if the defendant gets one of these pills tested and it's in fact just MDMA, and he files a motion for a new trial, or, I mean, would you agree then that this conviction can't stand?
We would be at different footing. We'd have to take a look and see what the testing actually reveals.
Well, if it reveals that it's MDMA, can this conviction stand?
It's difficult to say in a vacuum, but no, I think we'd be on different footing.
Okay. You've got 17 seconds. Oh, nope, you're negative. So I think we understand your argument. Thank you very much. The case is submitted.
Thank you, Your Honors.
The next case is 2022-P-677, Commonwealth versus Bracero. Morning, counsel. Whenever you're ready, Mr. Gaffney.
Thank you. Good morning, Your Honors. My name is Edward Gaffney, and I represent the defendant ZOILO Bracero. This is Mr. Bracero's direct appeal from multiple convictions of physical and sexual assaults on his niece when she was between the ages of 9 and 13. At the outset, I'd like to take issue with the many arguments the Commonwealth has raised in an effort to justify the multiple hearsay statements that were introduced at trial through JG, her testimony, and also the testimony of the DCF investigator. JG testified that she told one friend and then two friends and then a school counselor and then the DCF investigator that the defendant had physically assaulted her, beat her with a belt. And then the DCF investigator testified and repeated several of these hearsay statements.
So I just want to stop at the beginning and say, I want to make sure we're all on the same page as to the standard of review. And the Commonwealth is arguing that the standard on the admissibility of these reports is actually abuse of discretion. And do you agree with that?
Well, abuse of discretion is always, at issue when there is an evidentiary argument. I actually think, Your Honor, that the standard of review is an extremely perplexing question in this case because of the way that this evidence was handled when it was initially, when the niece started to testify about the conversation she had with her friend, there was an objection, a hearsay objection. And in fact, there were two hearsay objections, both of which were sustained. However, between the hearsay objections, the judge actually helped the Commonwealth get the contents of the conversation into the record. When the niece started to say, "I was talking about the physical stuff to my friends," the judge interrupted, asked the prosecutor to make sure that she clarified what she meant by the physical stuff, and that's when there was no doubt. We're talking about the fact that she told her friend.
And there was no objection at that point, right? So the objection came in, I think, when the victim started to testify as to what the friend said in response to her disclosure.
That's precisely right, Your Honor. There was an
And I'm going to interrupt you because I should have said at the beginning, this case is partially impounded. You've been very good about not using the name, and I appreciate that.
Thank you, Your Honor. Yes, I practice. It's going to be the niece or JG.
So how is this a preserved issue?
The argument I make in my brief with respect to the preservation of the issue is that there were two hearsay objections, both sustained, and that the action of the judge in actually helping, contrary to the sustaining of these objections, but the action of the judge in actually helping the prosecution get the contents of this conversation into the record made further objections futile. However, the Commonwealth is absolutely correct in its observation that there was no request for a limiting instruction. So,
Why would the objection be futile? I don't get that. I mean, the judge sustained the objection twice, right?
but in between, in the conversation, so there's objection number one, and then initially the Commonwealth, the prosecutor, didn't go right at what was said. But in the subsequent, in the following interchange between the prosecutor and the witness, the contents of the conversation came out. I talked about the physical stuff. And then the judge said, hold on.
Yeah, but wait a minute, but the objection, I'm seeing the objections here in the transcript, but they're not about the same thing that you're arguing on appeal. So, for example, on page 174 of Volume 3, testimony was the answer to the question, they gave me the courage when they sat there and listened to what I said about my story. When I told that story, they asked me if I wanted to objection. Yes, that's sustained. So clearly the objection was to what people were about to say to the victim.
And
so that's not what you're arguing on appeal, though. So there was an objection, but it's not for this reason.
And Your Honor, it's possible that the trial counsel simply was slow, or for some reason the trial counsel determined that hearsay only applied to what the friend said, rather than to what JG said. In other words, you're right. The objection came in on the and then she told me, and then she said, objection, sustained. But then the interchange right then, the sidebar, seemed to indicate that this was a rather broad discussion of the fact that the contents of this conversation shouldn't be in, and the judge at that point seemed to agree when he suggested, why can't you, just say this, did you disclose information? Basically lead with a yes or no question, and then after that say, why did you disclose information at this time and not beforehand? So it seemed that the judge got it in that sense, but again, when the conversation content ultimately came in, the judge was actually helping it. That's why Your Honor, I was saying that further objection, the trial attorney could have come to the conclusion, look, the judge helped them get this stuff in. Further objection.
If I could just defend the judge for a minute, isn't it possible that the judge was relying on the language in Commonwealth versus King that says that a victim may testify to the events or conversations that culminated in the complaint? Isn't that really what the judge is referring to?
I actually disagree with that, Your Honor. I think that language from King is talking not about previous conversations, because this is not the complaint of sexual abuse at this point.
But this is what led to it. This is explaining the background, how it was kind of a chain of events, right? Didn't it go victim to friend, to school counselor, to DCF?
Friend, two friends, school counselor, DCF. And physical assault, physical assault, physical assault, physical assault, then sexual assault. Now, I don't think there's anything in King or any of the cases that were cited by the Commonwealth that allows the Commonwealth to just walk all over the hearsay rule in just anything that happened in advance of the sexual, the report of sexual abuse is admitted. I don't read those cases to mean that at all. In fact, the cases cited by the Commonwealth, Hall is the one that comes to mind. There's another one, Montanez, I think, where the Commonwealth is entirely allowed to talk about state of mind with respect to, for example, why there was a delay. And in fact, that's what the prosecutor said she was doing here. But that evidence came in. The defendant threatened me. That's why I didn't do it. There was a code of silence. What happens in the apartment stays in the apartment. The mother telling her to lie. And then she said in 2013, I got over it. I got courage. I was able to come past that intimidation, and that's when I made my report of sexual abuse. That's all that's necessary, and I believe that the law says that that's all that's okay.
Does this argument relate only to the conviction for assault and battery with a dangerous weapon?
Well, specifically, yes, but I would argue because of the nature of the error, that, you know, as I see it, the multiple errors here, we've got a dramatic amount of evidence that's unfairly corroborating the testimony of the victim.
Jury acquitted him of one of the indecent assault and batteries, right? So doesn't that cut against your argument on prejudice as to the sexual assault?
No, Your Honor, I would put it in the other direction. I would say that that makes this a close case, and that we've got a close case where we have an uncorroborated set of, you know, no physical evidence, no forensic evidence, and then we've got the windfall. We've got eight statements.
But the only way that this hearsay argument you're raising relates to the convictions other than the assault and battery with a dangerous weapon is you're saying that it propped up her credibility, right?
Correct.
But the jury plainly did not find her credible, at least as to one of the charges.
Correct. So they did find her credible, though, to some others.
So isn't that some indication that this line of testimony did not prejudice the defendant?
Well, no, they convicted him. They believed her to some degree. So additional, in my opinion, you know, vastly unfair corroboration is going to help, and helped, and unfairly helped. That's my position here.
So the Commonwealth argues that the testimony about the disclosure of physical abuse was not unfairly prejudicial because it bolstered a defense theory that she wanted out of this house.
Right, Your Honor. No, that was a theory. The motive, the defense theory with respect to motive was she made complaints, therefore that got her out of here. However, the defense counsel was very careful because the evidence was that the mother and the father physically beat JG, and that's where she was going with her case. She very carefully didn't argue that in her closing argument. She had to mention it because it came in, like I said, 6 or 8 times, but she didn't lean on it, like the Commonwealth did, by the way, in their closing. They used it. And remember, there was no limiting instruction here. In fact, I keep thinking about this case as if, what if this was a report of a sexual assault? I mean, we'd all be thinking about the profound violation of the first complaint doctrine by this like multiply repeated testimony, no limiting instruction ever when it came in or at the end.
Yeah, but this really was brought out by the defense, though. Looking at page 221 in the transcript in volume 3, on cross-examination of the DCF worker, and it was also reported to you that her parents often hit her with a belt, correct? I mean, that was a defense theory, wasn't it? That she wanted to get out of that, she wanted to get out of the house because of the physical abuse that was occurring, right?
Her parents. Mm-hmm. That's a totally different story here. I mean, the defendant
I mean, this is all in the context of this, that's the end of the examination I'm referring to. But the question that preceded it was that she was hit by a belt by all three.
Right.
I believe so. So the point is, she wanted to get out of the house because she was being disciplined in a physical way by the adults in the house,
Well, yes,
including the defendant.
Yes, Your Honor, but again, the defense counsel had she had to work with this evidence that the mom and the dad were hitting her. She tried to stay away from that other evidence. By the time she got to this point, by my count, 6 times this evidence had been put in front of the jury. I mean, it may have been just a matter of like, okay, look, I've got to deal with it. Let me just make sure I don't appear to be running away from it to the jury. But by no means was she leaning on this. I mean, and how would she? I mean, he was being charged with, he was being prosecuted for that crime, for her to put into this case evidence which was never limited. I mean, it turned out to be not just corroborative, but able to be used substantively to prove he committed a crime that he was being charged with in this case. I mean, that's a pretty...
Well, I mean, as I see it, the only statements that came in on direct were in response to when the judge asked for clarification, and the victim says that she had told her friends about the hitting, the disrespect, the discipline.
Right.
And that's really the extent of it, right? I mean, this is brought under as a hearsay challenge.
Right.
But her saying, I told my friends about the physical, did you tell your friends about the physical abuse? She says, yes. That's not admitted for the truth, right?
Well, I mean, the prosecution said it wasn't, but I mean, it came in. There was no limiting instruction, so it was being used for whatever it was being used for. I mean, theoretically, and I'm aware of. By the way, I'm aware of no theory on which this stuff could come in. But if it was to come in under this kind of state of mind thing, then the judge has to make a determination that it was more probative than prejudicial. I mean, I'm not sure what the statement, my uncle hit me a lot, physically assaulted me, has to do with the victim's state of mind. But with respect to prejudice, I mean, it's vastly prejudicial. So in my mind, the balance is way out of whack here.
All right. Did you have any further questions? All set, thanks. I think we'll have to leave it there. We understand. Thank you.
Thank you, Your Honors.
We'll hear from the Commonwealth.
Thank you, Your Honor, and may it please the Court, Aaron Staudinger, Assistant District Attorney for Middlesex County, on behalf of the Commonwealth. And I guess I'll begin where we began with the defendant's argument. The standard of review is abuse of discretion. The purpose of an objection is to notify the judge of your objection and to allow him to make a correction. To say that a further objection was futile is somewhat a disingenuous argument. He clearly understood the hearsay objection that was made in the first instance, and then could have persisted in objecting to this line of questioning and chose not to. And for that reason, I believe the error is unpreserved and should be reviewed.
Well, Attorney Gaffney argues that the judge actually helped to get some of this
Yes.
in. So what are you supposed to do when you're the defense counsel in that situation?
Yes, and I think that kind of goes to my second point, or maybe my final point here, which would be kind of the way this evidence came in shouldn't be viewed as prejudicial. And I'm sorry that I know the question relates to the standard of review and less to the prejudicial, but I'll hopefully come back around. This line of questioning appeared to be in response to somewhat of an ambiguous answer by the victim regarding how this disclosure was made. She's kind of vaguely referred to the physical stuff. The judge prompts, can we clarify that? I don't think there was any question as to who the first complaint witness was, but the way the testimony came in was slightly confusing, and the judge was correct in saying, hey, can you clarify what she meant by that physical stuff? We don't want to cross into a bounds where there's some question as to who the first complaint witness is. And so then you'll see after that The questioning is almost as if a category. The prosecutor is saying, and who did you disclose the physical abuse to? Oh, to my friend. And then you disclose the physical abuse to 2 friends, yes. And then to the school
Right,
counselor.
but why does, I mean, this is not the first case. It seems like recently we're seeing many of these cases. It's like there was a conference and people said, hey, let's just have the victim repeat their narrative over and over and over that they told lots of people, and we'll all say it comes in as under state of mind. And it may in some particular cases, but it doesn't in most of these cases. So how are we to get a handle on this? Because it's too much.
And I
Maybe
think
not
that-
this case, but generally, there's too much of this going on.
And I think that the very important distinction here is that she is not making allegations of reports of the sexual abuse. This is regarding the physical abuse. And in that regard, I do think it goes very clearly to state of mind. The defense theory from opening was that she was manufacturing these allegations in order to get out of the house. And so it helped explain her delay in reporting. It helped explain the mental state of a child victim at that time. She's building up the courage to talk from talking to her friends.
But usually the Commonwealth does that with an expert witness that explains how people disclose. They don't do it by letting somebody repeat over and over again that they told lots of people.
Correct, and I can't speak to why an expert was not called in this case. The only thing I would say is that insofar as this countered the clear defense theory, that she was manufacturing these allegations, it was not unduly prejudicial to bring in this evidence that spoke to her credibility and her state of mind when this attack was clearly being made.
Even with respect to the conviction for assault and battery?
Even with respect to the conviction for assault and battery, I do believe so. This isn't a situation where she's testifying to the substance. Again,
Right, but let's say he was only charged with assault and battery. The victim couldn't get on the stand and testify that she told all these people about the physical abuse, right?
in the context of a case in which they were only charged with assault and battery with a dangerous weapon, it would most likely be viewed as unduly prejudicial to allow in this self-corroborating evidence, as the defendant labels it. But I don't think this is that context here. She had already testified on direct examination to being struck with the belt and to her uncle disciplining her and hitting her. And then in this, when we start transitioning from the allegations, from the incidents of physical abuse to the reporting of the sexual abuse, it was necessary to both give her state of mind for her reporting of the event of the sexual abuse and to lay a foundation for that first complaint witness. It gives a notion of how she transitioned into conveying this, these incidents of sexual abuse to the DCF and the first complaint witness. And then I know I sort of touched on it briefly, but I do think it's important that there could be no prejudice to the defendant where this was his defense theory. As noted, the details of this testimony, when the DCF worker actually testified as to getting the reporter being hit with the belt, that came on cross-examination, and it was in response to...
Is there a point, though, where the sheer weight of it, I mean, he's counted up, he says 8 improper statements. You agree it's 8 statements. I won't ask you about improper, but...
I think it's 8 statements that are complained about, but I think...
Where's the limit? I mean, if it were 12 or 24, is there some point where you would say, okay, that was actually too much?
And I think the distinction here is that it wasn't just 8 statements for corroboration. If you parse it, she's talking about her mental state, that gets rid of 3 or 4 statements. She's being asked on cross-examination, that's another 3 statements. Really what we have is 1 or 2 statements where she's just going through how this report came out, where she said, and then I told the counselor about physical abuse, then I told the DCF worker about physical abuse. I think the other ones are properly admitted for her state of mind. If it had persisted in just going over the testimony of, and then you told the friends again, and that had constantly come out, maybe, but I don't think that's the factual situation here.
So, I mean, state of mind comes in because it's relevant to a contested issue in the case, right?
Correct.
So what's the contested issue here?
I think there very clearly was an allegation that she was manufacturing these. There was a challenge to her credibility, manufacturing these allegations. That was earmarked in opening when he said she's telling a story here. And you'll hear that story changed. And so
how does allowing her to repeat, I told this person and I told this person, I told this person, go to that?
And that's where I think it's both for the foundation for the first complaint and for the state of mind evidence. I think you start to see a transition where she's testifying, I'm building up my courage when she's speaking to her friends. And this is clear state of mind evidence. It goes to her delay in reporting. It goes into how it was reported. Then she starts talking about, then you told the counselor, yes, I told my counselor about the physical abuse. Then you told the DCF worker, yes, I told the DCF worker about physical abuse. And I think that very clearly starts laying the foundation for the first complaint testimony, and that's where the testimony regarding...
Why can't she just say, over this period of time I was building up my courage? Why does she have to give the particulars about, I did it by telling this person and I did it by telling that person?
Yes, and I think that was, it's possible that it could have come out in a clearer way. I think the reason it happened in the manner it did here was, again, because she was somewhat ambiguous. The victim was somewhat ambiguous in giving that answer regarding physical stuff, and I think it was mostly to clarify what was meant when she said the physical stuff. It certainly could have been done in a cleaner way, but that's not what the standard review is here. It's whether it was prejudicial to the defendant, and insofar as he was utilizing this evidence to support his defense theory that he developed from the beginning. It wasn't like this defense theory was made up on the fly. He said in opening, she's telling a story, and you're going to see that it changes. I think the defendant benefited from this evidence, and therefore there can be no prejudice as a result of that.
So if there's no objection, wouldn't the standard of review be substantial risk of a miscarriage of justice?
Yes, Your Honor, sorry, I misspoke.
Okay.
Assuming we thought actually that this was not proper, does it only go to the assault and battery by means of a dangerous weapon charge, or does it, as your opposing counsel argued, does it implicate all the convictions?
I do not believe it implicates all the convictions. It only goes to the assault and battery conviction. I think, as you noted, insofar as that there's a substantial risk of a miscarriage of justice. I think, as we noted, that there was a not guilty on one of the indecent, so clearly they were parsing her credibility. And so, given that this could have only been corroborative of the assault and battery with a dangerous weapon conviction, it doesn't implicate the other convictions. And if I can move on to the second argument unless there were further questions on that first issue.
Proceed.
And just quickly with respect to the testimony from the victim regarding her involvement with DCF, the investigatory process by the first complaint witness and the investigatory process by the detective. I think with the victim's statements, it clearly went to her credibility. It was clearly more probative than prejudicial. She simply testified that she had been removed from the home after these allegations, and that she had, it was, quote, signed up, end quote, with DCF, which permitted her to receive support services after the age of 18 through college. This was clearly just establishing her relationship with her mother, who testified earlier in that she hadn't been in the home for some time, and it was merely a factual statement just as to where she was. Again, I don't think there was a substantial risk of a miscarriage of justice because it fully was utilized by the defendant in support of his theory that this was her motivation for being removed from the house, was to get into DCF custody and receive DCF services. So I think her testimony was completely innocuous in that regard. With respect to the first complaint witness, much of the complaintive testimony regarding her investigation of the victim was kind of just background information as to how an investigation occurs. I don't think it was particular to this victim, but was merely setting up, this is generally how an investigation occurs. The second complaintive evidence that she met with her individually, I think that went to the credibility of the victim, who had said, we were always told not to speak to DCF. My siblings were always told not to report, and I was suspicious that they were going to kind of interfere with the report if they knew that I was making this that I was making this report to DCF. And so I think that clearly went to her credibility. And importantly, the DCF investigator, the first complaint witness, the DCF investigator, never testifies as to the credibility of the victim. She never says, because of this process, I found her more credible. It was merely standard procedures that the investigator was going through. And the Commonwealth is allowed to present how an investigation occurs. It doesn't have to occur in a vacuum. Similarly, the detective's comments, or the detective's testimony regarding his investigation established the background for how an investigation occurs, how he became involved, and laid the foundation for his identification of the defendant, which occurred in court, and for the defendant's statements that were made during the detective's interview with the defendant, which were admissible as opposing party statements. They were self-incriminating, and they went to consciousness of guilt. So for that regard, that evidence was all properly admitted. If there's no further questions, I can rest on my brief.
Thank you very much.
Thank you
Case
so
is
much.
submitted. The third case today also is partially impounded, so we will not be using names of the victim. The case is 2021-P291 Commonwealth versus Gregory F. Landry. Whenever you're ready, counsel.
Please the court, Joseph Giacomo, arguing on behalf of Mr. Landry. The author of this brief, as you know, is no longer with the panel, and I am arguing it. But the author of this brief on behalf of Mr. Landry focused on three arguments. And I would like to address the text statements. And if you would give me 5 seconds. We all have read the transcript, I presume. We all have read the 20-some pages of text messages. In putting it in context, I would suggest, did any of us not feel moved by this young individual? I would suggest not. And therein lies the issue. The main theory behind the first complaint is first to refute the false inference of silence. And second, and most relevant here, since the accusation was not days old, but hours old, to prevent the prejudicial piling on, to prevent emotions going to the jury. And I would suggest to the court that if we cannot look at those 20 pages of text messages and feel extremely sad for this individual, this young individual, then how can we say that what went in was not unduly prejudicial? It had no probative value in any way, shape, or form, I would suggest to the court.
Well,
Go ahead.
you could make the same argument about demeanor evidence, right, which is admissible. Demeanor evidence comes in, it might make the jury feel sympathy for the victim, but it's relevant.
I would suggest, yes, it is.
Right.
But there is a scale of relevance, and I would suggest in this situation, the tender age of the alleged victim and the 20 or so pages of context, for lack of a better word, upstairs in a makeshift bedroom, having to go to the bathroom, not being able to go downstairs because Mr. Landry's downstairs, not being able to leave because the alleged victim cared about the children, the minor children that she was babysitting. And the texts that were coming back about how I love you, and I'm paraphrasing here, how I would do anything for you, I hate what's happening to you, before the individual action, before there was a first complaint made, set a highly sympathetic picture, which I believe, if you just give me 1 second, I believe permeated the entire trial, not just this one count that we're talking about. Yes, Justice Edwards?
Well, have you found a case where we or the SJC has reversed a rape conviction because too much of a text conversation around a first complaint was admitted? Because I haven't.
No.
And I have seen that when the judge doesn't put the whole thing in, the defendant challenges that.
Go ahead, I'm sorry.
No, I mean, I agree at some point there's a limit. I'm just not clear we've reached it in this particular case.
If not now, when? Realistically. If this was just a 20-page conversation between the alleged victim and a friend who it seems had intentions of more than friendship, that the individual actually probably was attracted to her, as young children are.
I guess the question, though, is, I mean, you know, this is how young people talk today. I think many of us might be perplexed by that, but I'm not sure the 20 or, in fact, 29 pages of text message are the issue. I mean, she's having what, for this age, is a conversation, and we would allow the conversation to come into evidence.
I think it goes past what I see my 15-year-old daughter engage in, or my 12-year-old daughter. I had kids late. You're looking at me like, how can you have someone, kids that old? It goes way past what I see in texting, monitoring their phones. This was I would suggest, again, was an extremely sympathetic line of back and forth. And again, you know, I'm going to argue it's prejudicial. The Commonwealth is going to argue it's not. I think we can all agree it had no probative value. But again, if any of us here read that and didn't come away with a tear in their eye, then how can we suggest that the jury was not affected by it? Whether there be a case or not that has arisen case law-wise or made it to the SJC, I think is irrelevant. It doesn't preclude this court from saying, well, time out, this is enough, this was overboard, there was an error, and it prejudiced the individual. Now, the Commonwealth is going to argue, well, after that, there was a statement made, I was raped. So is it harmless? No, I don't think it's harmless in any way, shape, or form, because it set a sympathetic stage in the juror's mind.
So the way this was briefed by your predecessor counsel was as a hearsay issue. But I hear you arguing now that it's more of the prejudice, unfair prejudice, outweighing the probative value. Which is it?
I don't think they're mutually exclusive. I don't think they are mutually exclusive.
Well, which part of it was hearsay? What came in for the truth?
Nothing came in for...
So it's not hearsay.
Are we to assume that what her state of mind is coming in for the truth? We may very...
No, I mean, if it's state of mind, nothing's coming in for the truth, right? You know, I want to die, things like that. That's not coming in for the truth. So it's not a hearsay problem. It's not a first complaint problem because there hasn't been disclosure yet. So is your argument that the unfair prejudice outweighed the probative value? Is that what we're talking about?
I'm sorry.
Is your argument that the unfair prejudice outweighed the probative value?
For sure. For sure, and I think my predecessor stated, I know my predecessor stated that, and after reading it, I would suggest the same thing, that it had no probative value, and again, it said,
So
the argument was that it came in as part of the first complaint. So I would suggest to the court that it has to be reviewed as part of the first complaint
But
doctrine.
it's not independently, it's not a violation of the first complaint doctrine, right? Because there's been no disclosure yet.
I don't believe that the first complaint statute can be read that way. I think the underlying theory.
Okay, well, let's say let's say that the friend testified, she called me that night and she was hysterical and crying, and that would be admissible, right?
Would be.
That would be admissible, right? And then after hysterically crying for 1 hour, she told me she had been raped. All of that would have been fine, right?
Yes.
Okay. And so why is it that the Instagram messages are not considered in the same light?
It goes back to the underlying theory with reference to the first complaint as elicited in Commonwealth v. King, the piling on. Hi, so-and-so, I just got raped, as the person is crying, is a 3 or 4 sentence strand. Here we have 20 pages of setting up a scene, and I don't mean to be cavalier, but setting up a script like a movie script. I'm upstairs, I'm in a makeshift bedroom, it's a attic, it's fold downstairs. I can't go to the bathroom because I'm scared that Mr. Landry's downstairs. I can't call my mother and wake her up. I can't call my father. No, I don't want to tell you. 2 or 3 statements preceding an admission compared to 20 pages of, and again, I'm trying to tread lightly here, of the only way I can categorize it as drama, was overly, I believe, was over, and prior counsel was overly prejudicial to Mr. Landry. And again, I think that it was definitely a script
Well, you would,
or a movie to paint a sympathetic picture. And again, I say that with all due respect to what allegedly happened here.
you had mentioned the King case, and in that case, the Supreme Judicial Court had said the evidence may give as complete a picture as possible as to how the complaint arose. So if in today's methods of communication that people have, they're kind of slow and tedious and over a lengthy period of time through text messages, can't that same amount of information be conveyed in that 5.5-hour period as might be conveyed in a 5-minute telephone conversation?
I would suggest not, Justice Hodgens. And the reason is that with reference to the case that you mentioned, and you look at this case, would it have been okay that I passed out, I was in the hot tub, I passed out, I came to, I found myself on top of Mr. Landry and everything else? Yes, I would agree with you that that would be fine. But where does the slippery slope begin and where does the slippery slope end? And law is always evolving. One of the great things about Scalia was he recognized that. And it has to involve it has to evolve because of society. So just like when my son goes to bowling and you have to put up the guardrails, the court has to look at what is transpiring within society and say, okay, where is that demarcation line? Where do we put up the guardrails in a situation like this when young adults engage in hours and hours of texting? This went over the guardrails because I would suggest to you 99% of this conversation was an individual trying to elicit what happened and an individual saying something bad happened, I want to die, I can't go downstairs, he's down there. The emotional impact of the underlying words in those 20 such pages clearly went over any guardrails that I would suggest any court would set as society evolves and we have to deal with how kids now communicate, whether it be text or TikTok or whatever those things are that I don't understand.
We understand your argument, and we'll have to leave it there.
Thank you for your time.
We'll hear from the Commonwealth.
Thank you. May it please the Court, Mary Nguyen on behalf of the Commonwealth. With respect to first complaint, the rulings of both judges in this case, so that would be the motion judge as well as the trial judge, they were in accordance with the law with respect to first complaint. This is a situation where King actually defines what circumstances are. So the first complaint witness may testify to the circumstances surrounding the initial complaint. And the King case, in defining what they meant by circumstances, they did say that it includes the events or conversations that culminated in the complaint. In this case, the events and conversations that culminated in the complaint were the text messages, which the judges carefully considered and also excluded a substantial portion of the messages, and then the trial judge also had a redaction. So this was a case where, well, first of all—
counsel, I think what we've basically heard is an argument that this is very different from somebody saying, well, you know, I said so-and-so and I said this and that, versus in this case, the jury's basically dropped into the middle of the scene of the events and then is taken through literally line by line for 8 or 9 hours, and that is too much.
Well, sure. So this is, and you know, actually King and also Aviles, I believe, actually addressed this issue. The first complaint evidence is not limited to just the facts of the complaint only. So both predecessor counsel who authored the brief and also defense counsel at trial, if they had it their way, it would just be limited to the text that morning where she disclosed the rape. But that's not what the law, the first complaint jurisprudence says. It says it's not limited to the facts of the complaint only, and in fact, there is, the law is that it's actually about allowing all the details in. In this case, these were the circumstances. We take the facts as we get them. The judges were careful in their analysis by making sure it was concise, by excluding—
Is there a line?
I'm sorry,
Is
Judge?
there a line? I mean, youth today seem to be are prolific with the texting and the instant messaging and stuff. So, I mean, if this had gone on for 3 days before she disclosed, would that be okay? Would we, if it was 100 pages, like where is the line? What is the standard?
Sure, Judge, and this is why trial judges are afforded the discretion in their particular cases. It's not a statute, as my brother indicated. First complaint is a body of governing principles. The question is, was there an abuse of discretion here by the two judges? I submit to you that based on the precise facts of this case, where the judge narrowed it down to those pages 29, I believe it was, if I'm not mistaken, with the redaction, that, there wasn't a situation. The judges they did what they were required to do with their careful and thorough analysis. But moreover, I just wanted to return to some of the jurisprudence where both King and also Avil talk about the benefit of giving the jury all of the details. Some language is giving the jury the maximum amount of information to allow a fuller assessment of a complainant's veracity. That's Revels, the appeals court case, talks about that fuller assessment. King is the one that actually talks about giving, this is, I quote, "By allowing in evidence all of the details of first complaint evidence, the doctrine gives the fact finder the maximum amount of information with which to assess the credibility of the complaint evidence, as well as the overall credibility of the victim. It's because the law has recognized the benefits of providing the jury with more, not less, information when it comes to the details of the first complaint." And moreover, this is not a situation where the defendant can show any prejudice. So moving on to sort of the prejudice prong.
Well, why is it not enough to say that she texted this friend at, whatever time and said something upsetting had happened, and then, they had conversation for 9 hours, and then she said that she was raped? Why is that not
Because,
sufficient?
Going to what the goals of the first complaint doctrine are, one of the goals is to give the jury, as Justice Hodgens quoted, a complete picture as possible of how the accusations of sexual abuse first arose. And again, I just repeat that King has specifically addressed this issue, and it says first complaint evidence is not limited to the facts of the complaint only. They want all of the details and circumstances, obviously with the rules of evidence in mind, and that's why it's to the judge's discretion. They're given this discretion to make rulings specific to...
On that point, so the judge, having wide discretion here,
Sure.
could have agreed with what counsel's arguing now, defense counsel is saying now, and said, well, wait a minute, 5.5 hours of text messages, this is over the top. We're going to limit this to, 8:52 a.m. in that range, I got raped, a few messages before that, and that's it, right?
Sure. So it's sort of, not to be repetitive, but it's not limited to the facts of the complaint itself. That is the first complaint jurisprudence.
But the judge would have discretion to do that. If the judge agreed with what defense counsel is saying now and said, yeah, this is an awful lot here.
Well, the judge has wide discretion, but they have to, that has to be based on the principles of the first complaint doctrine, which includes one of the goals of the doctrine, which is, again, to give the jury as complete a picture as possible of how the accusations of sexual abuse first arose. So as King has talked about explicitly, first complaint isn't just limiting it to that one sentence where they say, I was sexually assaulted. The jury gets to hear the complete picture and the circumstances, and they define what they mean by circumstances, and it includes observations, for example, of the complainant during the complaint. In this particular case, relevant is the events or conversations that culminated in the complaint. So how did this complaint arise? If you read the text messages that were admitted, she was reluctant in the beginning, and it was a little bit of back and forth, where she finally did disclose at the end. But the jury gets to hear all of that. How did she finally disclose? Because it's all drawn out in that one conversation. So I hope that answers your question.
Do you agree with defense counsel that this is a preserved issue?
I'm sorry, Judge?
Do you agree with that this is a preserved issue? Because the way I read the filings, the defendant's opposition in particular, there was some question who was the actual first complaint witness, and that seemed to be the basis of the dispute.
That was initially, that's why there was a voir dire
And is there
hearing.
some place later where do you agree it was preserved at some point?
As far as the scope?
Yeah.
I think I do agree, because when they were having the hearing, he articulated you know, his argument, counsel that is, defense counsel, is that it should be limited to just the
Hearing on the motion.
Yes, the hearing on the motion, that it should be limited just to that fact of the complaint, which would be the one sentence at the following morning at 8-something in the morning. So, and then there was a motion hearing, there was oppositions, motions to reconsider. So it wasn't, the only issue wasn't just the identity of the first complaint, which was resolved during the voir dire. I think that I would say it was preserved as also in the scope issue. But I think ultimately, though, we don't even get there, but I do want to talk about prejudice in the event that you think there was an abuse of discretion. But the Commonwealth's argument is that there was no abuse of discretion. But moving on to prejudice, even if Your Honors were to find that there was an abuse of discretion, certainly there was no prejudice here. This is not a situation where there was a parade of multiple complaint witnesses. This was limited to one witness, the friend, and one complaint, and about one incident. There was no piling on, which, you know, it's talked about in the Stuckish case, which is cited frequently. And then, importantly, there were 3 limiting instructions by the trial judge, 2 of them contemporaneous with the evidence as it was coming in, and then 1 in the final instructions. And certainly the jury is presumed to follow the judge's instructions, so it didn't come in substantively. And I know there was a reference to hearsay. It didn't come in for the truth of the matter. It came in for a limited purpose. The jury was instructed 3 times, and they're presumed to follow those instructions. And then I also talk about, in multiple regards, but also on this issue of first complaint, about the substantial other evidence, the overwhelming evidence in the Commonwealth's case. In addition to the complainant's very detailed testimony, we have evidence of the defendant's reaction when the defendant woke up from her state of unconsciousness, told the defendant to get off of her. His reaction was to apologize. I'm sorry, nothing happened. And then thereafter, there's repeated verbal apologies following this assault throughout the night and into the morning. There was the incident, if you recall, with the sword, an item that looked like a sword. He handed it to the complainant and said, "Stab me, I deserve it." And then the text messages between the parties, where there were, I submit to you, more apologies. In addition to that, when you think about corroboration of the complainant's testimony, we have not only medical testimony, but also photographic testimony of injury to the complainant's shoulder, thereby corroborating her account of being held down by her shoulders with force, to the point where there's documented evidence of that. And then there's the consciousness of guilt evidence in this case. The defendant arriving home from work a mere 3 hours later, which was unusual for him, the deleting of text messages from his phone. So certainly, I submit to Your Honors that there was no prejudice can be shown here by the admission of first complaint evidence. Any other questions with respect to the first issue? Unless there are questions about the other issues, I would rest on my brief with respect to that.
What's your best case on the custodial interrogation? Like, what's the closest where somebody's asked one open-ended question in the backyard or in their home?
So I went through the sort of the factors that were outlined in Groom, but I think a case that I cited a few times was the Lavendier case, because I think in this particular case, I think it's important that at no point, when we're talking about the focus of the investigation as one factor, at no point did the officer communicate to the defendant that he was a suspect. At no point was the defendant, when we talk about the freedom to end the interview, admittedly, as my sister below argued, it did end in arrest, but that's not the determinative question. The question is whether or not it's relevant only insofar as the officer communicates to the defendant that he's not free to leave. And in this case, that was not communicated to the defendant when the officer asked that single question, which I submit to you was a general preliminary inquiry that was not accusatory.
All right, thank you. The case is submitted, and we'll take a short mid-morning break.
Thank you.
Court is now in recess.
Welcome back. We're hearing our fourth case of the morning, 2022-P-568, Department of Children and Families and Others versus Mother. This case is impounded, and I want to specifically say that, you know, the briefs used the children's first names, and I'm concerned about that because usually that means that the attorneys accidentally say them out loud. So we're not going to do that today. We can refer to the child at issue and then the younger siblings, but we don't need to name anybody, okay? And with that, counsel for the mother.
Good morning. My name is Lois Farmer, and I represent the appellant mother in this case. This case presents some unusual issues that don't arise all that often. Specifically, there are issues that arise under the Indian Child Welfare Act, ICWA, and they form a major part of our objection to the decisions of the court. Under ICWA, in order to meet the constitutional due process rights of the mother, that is her constitutionally protected interest in her relationship with her child, the petitioner has to prove beyond a reasonable doubt, which is higher than Massachusetts proof, beyond a reasonable doubt, that the DCF, in this case, took active efforts in order to reunite the mother with the child, reunite the family. And in addition, under ICWA, the petitioner has to produce evidence by an expert witness, must produce a witness who has child welfare expertise, education, training, doesn't have to be a practicing clinician, but has to have that level of education and experience.
Both of these provisions are being reviewed by the Supreme Court.
Yes, they are.
Correct?
And I'd like to mention that the Commonwealth of Massachusetts has joined amici of 24 other states affirming these provisions.
Well, I don't know if that's relevant, but if the Supreme Court strikes down these provisions under the 10th Amendment, then much of this appeal will be mooted, right?
I would suggest if these provisions are stricken, then this case would have to be remanded because the case
Why?
was tried under ICWA. And if it...
But why does that matter if the burden is higher in a case under ICWA?
Because if then if it's determined that ICWA should not have applied, then we still have to look at some other issues under Massachusetts law, and I can get into those.
Right. No, I'm asking, but those issues have been briefed, so we can decide those. I don't know why there would be a new trial.
Well, I think that the situation, I think it was the child who said that the active efforts is kind of similar to the reasonable efforts under Massachusetts law. And I do agree that the general aspect of that is the same, because under the reasonable efforts and under the active efforts, what has to happen is the DCF has to look at the reality of who the mother is and has to take active or reasonable efforts to address the barriers that the mother faces in being able to be fit to have custody of her children. And in this case, I don't care whether it's under ICWA law or Massachusetts law, DCF did not do that. So if I can go to the issue of ICWA versus reasonable efforts, what did the DCF do or not do? What should it have known? What did it not address? In March of 2017, mother went into active labor, had a parenting plan. Her father was to take the older son, TM, while she was giving birth and hospitalized. She appeared before at the hospital. She had not been able to make contact yet with the father, so hospital decided the child, TM, who was with mother at the time, would have to go home with the maternal grandmother and an aunt. Now, this mother, my client, had already been removed from her mother's household due to drug abuse and domestic violence. My client did not want TM to go to that house. Even when mother was staying in relatives' houses, she always made sure TM was never out of her presence because of the background. Mother was upset, understandably so, I would suggest. The hospital was having difficulty figuring out how to deal with it. They call the DCF. The next day, the social worker, who was not there at the time, actually informed DCF the child should not have been removed. There was a parenting plan, mother's fine. Nevertheless, now you have TM in DCF custody, and at the same time, the younger son was also placed into custody. So what happens next? The tribe takes over, gets mother housing, mother's able to get jobs and have babysitting through the auspices of the tribe.
I was unclear whether that housing had room for mother and, at that point, both children, or did it only have room for mother and the younger child?
I think it had room for both, to be honest with you, because the thing is, the younger child is an infant, and then there was TM. And if you look actually at part of the history of JM's father, when he ultimately took custody, was living in a single room, and his son was to share his room. There's really not much difference there at that time. It was a stable housing at first and a hotel with a kitchenette, so there's housekeeping abilities, and then afterwards went into a tribal home. So I would suggest that that would have been sufficient, and in fact, DCF went before the judge and said, mother is doing well. She is following her tasks. She has the support of the tribe. We suggest that you let TM go back to his mother, as well as JM. And for no reason that the judge clarified, the judge decided against that and decided that TM had to stay in DCF custody, but returned JM provisionally to mother. So also at that time period, we have the judge saying, and this is just on oral argument, but nevertheless, the judge said to mother and mother's counsel that mother is to take shelter housing, I don't care where. Took a little while. Mother finally, herself, not through the assistance of DCF, herself found ultimately housing in Springfield. She got assistance to move up to Springfield. She notified DCF, asked DCF to move services up to Springfield. They refused. In the notes from DCF, mother asked for a parent partner. Mother was focusing on trying to get more housing and employment. DCF did not address those issues. In the meantime, being up in Springfield, mother had visitation with TM on Cape Cod. DCF did not give assistance for that. Nevertheless, mother came down as much as she could, driving this, or carting basically her infant 140 miles by bus each way to visit with her son, or to go to her medical appointments, or to go to court, without assistance from the DCF. The mother provided medical care for JM, the son, the infant. Went to the hospital. DCF checked. Did mother go to the hospital? And the hospital says to the mother, it's in the DCF records, that yes, the mother came, and yes, the child had a rash, but when you're in shelters, bug bites, scabies are common. DCF took no action to get mother out of that shelter, which was unhealthy.
Can I just ask you a question? And I don't mean to cut off your timeline, but if I could just go forward a little bit. What originally, when this petition began, the goal was reunification.
Yes.
What was the precipitating event, if you know? What was the precipitating event that changed from reunification to termination?
I'm not positive, but I'm thinking that it was when JM was removed as a result of this issue during the Springfield shelter. Mother had to come back to Cape Cod. She had medical appointments. You'll note that mother was scheduled for a neuropsychology evaluation in December. She had visitation with TM, and excuse me, although the doctors said, listen, this baby was always clean when we saw it, when mother was living on a couch at a family member's house. She went out to try to get some food for the infant, and she went out without a coat on the infant and possibly herself. This was discovered, JM was taken. That was the end of any child being in her custody. And I think at that point, through those evaluations, the goal changed to now terminating the custody and finding other homes. For JM, it was simple. There was a biological father in the picture. For TM, the goal was then to have a permanent placement. And the permanent placement is not adoption. It is guardianship.
But
So
now,
I
was there also a family action plan that mom was not compliant with?
There was a family action plan that was developed at the very beginning, and the family action plan had tasks for mother, for the baby, and also, of course, for the DCF. The plan never changed from day one. It was always kind of the boilerplate. You're going to get a psychological evaluation because it was known that mother did have mental health issues. So that she was supposed to be getting the evaluation. You're going to take the medicine, you're going to stick to the medicine no matter what. You're going to get the housing, you're going to do all these things. So there's an action plan. But please remember, DCF obligation, whether under ICWA or under a reasonable efforts in Massachusetts, requires when you have a special needs parent that you identify the deficits and you take action to work with and around and figure out how mother can get over those barriers. Having a set of tasks that are established at the beginning, we're working in the beginning, yes, but thanks to the tribe stepping in and giving this assistance to mother. Once that ended because mother was forced into a shelter, because that's what the judge wanted, there was no place else for mother to go. I mean, these tasks had to be changed. And if you look at the tasks that DCF set for itself, and I'm quickly looking at exhibit page number 87, we'll meet with the family, we'll contact collaterals, we'll attend court, we'll attend collateral meetings, yes. We'll meet with TM in placement, of course. We'll provide family members with information and referrals. We'll coordinate parent-child visitation, and then we'll convene a permanency planning if appropriate. No active efforts.
As you know, under state law, just Massachusetts state law, any question about reasonable efforts has to be raised in time for DCF to potentially accommodate the parent's concerns. Are you saying that in a ICWA case that it's reviewed after the fact?
There were challenges throughout the trial, is what I'm saying. The mother's attorney.
While the case was pending, does the parent not have any obligation to raise prior to trial, raise the question of active efforts prior to trial?
I think that, I understand the question of notice. I don't know whether that notice was given expressly. I would suggest that the mother was very clearly somebody who needed these active efforts, and I just don't think that active notice is required. I mean, the notice was
why wouldn't it be required?
Because at this point, you have the assistance. Initially, you had the assistance of the tribe, and they were providing the active efforts. After the first trial, at the very least, certainly DCF had notice, because I raised that in the appeal after the first trial.
In your brief, you say that this issue is reviewed de novo, and you cite a Washington appellate court case. Is that the only case that's decided the standard of review that you're aware of?
Under ICWA, no, they all say that the cases are reviewed. The question of active efforts, the questions of
cases all say that active efforts is reviewed de novo?
Yeah, that was just the one that was handy that I chose, but I've seen that throughout the case law.
That case doesn't cite any other case, so that's why I'm asking.
Yeah, I can get those.
Because the way the statute is worded is that the party here, DCF, must satisfy the court that active efforts have been made, which to me indicates
the party,
some sort of discretionary standard of review.
Well, I would suggest that the party being DCF has to persuade the court that the active efforts were taken.
Right, to
not the mother.
satisfy the court, right? And
Yeah.
so the court here, the judge, plainly found active efforts were made and outlined some of the ways. So doesn't the wording of the statute suggest we review that for abuse of discretion? Satisfy the court is what it says.
Right. I would have to look at the law again. I just.
Can I ask you, I know your time's running, can I just ask a question about the expert witness?
Sure.
Do you read the statute and the regulation to require a psychological expert in every case?
It requires a child welfare expert. It can be a social worker, but a social worker who is trained in child welfare and psychological type of issues.
If you had a case where the child is subjected to really extreme physical abuse or sexual abuse, the federal law would still require DCF to put on some sort of expert to testify as to the likelihood of harm.
What it is testifies to the future likelihood of serious emotion, not past, but serious.
I understand. So let's say that it's a case of extreme physical or sexual abuse of the child. DCF still has to put on an expert?
I believe so. Under ICWA, it's a must. ICWA says must. With regard to cultural issues, ICWA says should. So there's a distinction there, and the cases all seem to say that, yes, you have to have that child welfare expert, which I don't think would be difficult to do in the type of case that you've suggested.
Thank you very much.
Thank you.
I understand we'll have a time split with the department. We'll take 10 minutes and the child will take 5?
That's correct, Your Honor.
Excellent.
May it please the Court, Richard Salcedo for the Appellee Department of Children and Families. The Department is asking this Court to affirm the trial court's decision terminating mother's parental rights. A careful review of the Court's more than 200 findings of fact, all of which are unchallenged, show that close attention was paid to the evidence, and taken together, they support the trial court's conclusions.
Well, let's pick up where we were towards the end, which was, does ICWA require, say, you must have presented a particular kind of expert?
It does not. I think the statute, the regulations, and the guidelines that have been promulgated by Congress to provide additional guidance with regard to ICWA is worded broadly, and clearly, since these cases involve children and their child welfare nature, the expert witness should have a background in child welfare, but also in have a Native American
The
regulation, as well.
The regulation plainly says there must be an expert qualified to testify regarding whether custody by the parent is likely to result in harm to the child.
That's correct, Your Honor.
The Attorney Betancourt was not qualified as that kind of expert. She was qualified as an expert in Native American traditions and culture.
First of all, the regs do not specify that the witness needs to be a social worker or a clinician.
I understand, but it says that they must be qualified to testify as to the likelihood of harm, and in this case, she was not, in fact, qualified to testify. I'm not sure she could have been either, because this is someone who doesn't even have a background in social work.
No, but she has a background in child welfare. She's served as a court investigator. She's served as a guardian ad litem.
Doesn't the legislative history and all the cases addressing ICWA say that something more than the qualifications of a social worker are required?
And I would argue that this witness possessed those qualifications. She had
something more than a social worker. She doesn't even have any background in social work.
But she has served as a court investigator, which by nature would require that she evaluate evidence and make decisions or determinations regarding a parent's
Should
fitness
we
and likelihood
wait
of harm.
until the Supreme Court rules on the pending case?
I would say no, Your Honor. I also just wanted to point out that the question of this particular witness's qualifications was not raised beforehand. There was no objection, no issue about whether she was qualified.
Well,
Clearly,
the mother says that there was no objection for when she was qualified for the area she was qualified in, but when you get to the key point about whether returning the child would cause harm, there was an objection because she wasn't qualified.
well, under the statute, it clearly requires that the person who's qualified not only be knowledgeable about tribal customs, traditions, but also render the opinion about whether returning the child to mother's custody would result in harm to the child. That's known beforehand. And they raise no issue about whether this particular...
Statute is more ambiguous, but the regulation plainly says the expert has to be qualified on the issue of harm to the child.
I agree with that, Your Honor. In this particular...
But she was not. She was not qualified. I mean, if you look at the motion to qualify her, it said we moved to qualify her as an expert in Native American traditions and culture.
And what the objection was...
And there is no objection to that, and that's not being argued on appeal. The objection is she was not qualified to testify as to the likelihood of harm. So you don't think we should wait until the Supreme Court issues its decision?
I do not, Your Honor. I think this record could be, or your decision could be based on this record, and
well, if the Supreme Court strikes down this provision, then wouldn't you agree that a large part of this appeal would be mooted?
I think, no, I think the court and the record supports the, under mass law and under ICWA, that this particular witness was able to render an opinion based on her review of the record. And she's been qualified, incidentally, as an expert in ICWA cases in Massachusetts.
Well, let's say we disagree and that she does not meet the qualifications, the requirements of ICWA. Then you don't think we should wait to see if the Supreme Court invalidates this provision?
I don't believe so, Your Honor, no.
All right.
Let me ask you something. Now, putting aside the issue of the objection, we still have a trial judge under state law who has an obligation to be a gatekeeper whenever expert testimony is offered. And part of the reason we permit expert testimony is because it's supposed to help the trier of fact. Now, if we have an expert who comes in, box, when asked if returning the child to the parent would cause substantial emotional or physical harm, that box gets checked. But there's no explanation as to why. There's no explanation for the basis of that expert opinion. How is that helpful to the trier of fact?
I would disagree, Your Honor. I think what the witness testified was that the child has been in a stable home with a tribal foster mother, someone who's been active in the tribe, and that who has provided for the child's particular needs, emotional, physical needs, for almost 6 years now, continuously, or 5 years, I should say.
Right, but was the inquiry is not whether removing the child from that great foster situation was going to be harmful. It was whether putting the child with the mother was going to be harmful.
And I was going to continue with that point, is that the witness further testified that mother has not been able to provide or stabilize her home, and that she continues to have or struggle with homelessness and unstable housing, that she has not addressed her parental shortcomings through available services that have been provided to her throughout the history of the case.
So why was Attorney Betancourt, what was the expertise that allowed her to offer that opinion versus, say, common sense?
I would say what I had mentioned before, Your Honor, that she has extensive experience in child welfare cases, has served as a court investigator in a number of, over a many-year career, and as a guardian ad litem in child welfare cases. She's conducted trainings on ICWA cases, and she's been qualified as an ICWA expert in multiple cases in juvenile court proceedings in Massachusetts.
On what prong of the regulation has she been qualified?
I think both prongs. She would have to be in order to provide the
Didn't the
required
judge
testimony.
express some doubt as to whether she's qualified to testify about the likelihood of harm when he said, well, that's why you have the social worker who, I think by statute, or at least by regulation, cannot be the expert under ICWA, right? The ongoing social worker cannot be the expert. And the judge says, well, that's why you have the social worker who can testify about the impacts on the child. Doesn't that at least signal that the judge himself didn't think that Attorney Betancourt could testify about this?
I don't recall the judge expressing doubt
So
about...
that's why you have Ms. Lasko, the social worker. I mean, under Section 1914 of the statute, it seems like a decree is open to collateral attack by either the parents, the tribe, the child, if any provision of this statute isn't complied with. I mean, isn't that a concern as far as we're talking about stability of the child? I know this case has been going on for a long time, but the way I read that statute, it's open to attack later.
I don't believe that's the case, Your Honor. We have a termination of parental rights case here. I don't know.
But the ICWA says that if any of these provisions are not complied with, any parent, Indian child's tribe, the Indian child, his or herself, may petition any court to invalidate such action, meaning the termination decree.
And I believe that the provisions of the act were complied with, and the tribe was involved in this case from very early on. The tribe was aware of the expert who was being proffered by the department. There was no objection expressed by the tribe with regard to the expert's qualifications. And I see I'm running out of time, but I just would say...
Before you go, let me just ask you another question. Before expert testimony can carry any weight, it can't be sort of a secret recipe. It has to be something that can be replicated. If some standard is applied, can you point out to me somewhere in this testimony where this expert applied some identifiable standard in her field and drew a nexus between the shortcomings that you identified for me before, the shortcomings of the mom, and the nexus between those shortcomings and the harm that would befall the child? Was there testimony to that effect?
There was testimony, what I had mentioned before, that the child is in a long-term, very stable placement whose needs are being met for the past 5 years, and that mother continues to struggle and has no stable housing, has not stabilized her life, addressed her serious parental shortcomings throughout the case, despite services.
Accepting all that, but did the expert ever then draw the link between those facts in harm that would therefore befall this child?
Well, she was asked if returning the child to mother's
Right, it was a conclusory.
Right.
Her testimony was conclusory. She just said, yes, it would.
Right.
But there was no testimony drawing that link, was there?
Other than what I just mentioned, that the child's in a stable home and mother is not stable and has been unable to stabilize her life throughout the case. Other than that, no, Your Honor.
Okay.
So on page 37 of your brief, you argue that there are 3 types of experts who would be qualified under the Act. Which and then you list the 3 types. Which one of those 3, or multiple ones, was this particular expert qualified as?
I don't have that in front of me, Your Honor, but I think it's the 3rd one where it talks about background education.
Substantial education and experience in the area of his or her specialty?
Is this a guideline that's still in place? I mean, it was from 1979, right?
Well, 2016 is the most recent guideline, was the final rule by the Bureau of Indian Affairs, and I'm sure my sister will be able to talk more about that.
Do the 2016 guidelines say anything like this?
About the...
The 3 types of experts, people...
It's actually broader language than that. It's more, it doesn't sort of limit the qualifications of the expert. Unless there are further questions, I'll yield to my sister.
I think we'll have to leave it there. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Natalie Hoppel, and I represent the child in this matter. Your Honors, in terms of following up with my sister and my brother's argument, I'd like to focus on 4 areas which I believe would support this court upholding the lower court's judgment. First of all, Your Honors, expert Betancourt was qualified as an expert in Native American cultures and traditions. And expert Betancourt was qualifiable on the papers. That would refer the court to her resume.
I missed that part, I'm sorry.
Expert Betancourt was qualifiable on the papers as an expert.
In what?
In determining whether or not, or opining whether or not, returning a child, removing a child from their current home and returning them to mother would result in substantial harm.
But what do we do where she didn't actually get qualified as that by the court?
I think,
and when
Your
she
Honors,
tried to offer that opinion, there was an objection.
Yes, Your Honors. And I think to the extent that there was an objection raised, there was also no motion to strike her as an expert. There was no motion to strike her testimony. There was no motion to potentially reopen voir dire and have that take place at the trial while it was ongoing. So to the extent that Mother's trial counsel simply objected to the conclusion that was raised, there was no follow-up at the trial to strike the testimony, to strike her as an expert, and then a request to open voir dire. My sister brings up in her brief that expert Betancourt she questions her methodology, and to the extent...
Well, if I could just interrupt you for a second, I mean, it's a little bit unrealistic. I mean, if you're the party that is opposed to the expert testimony, and you see that it's a deficient presentation, I think it's a matter of strategy. You're not going to stand up and apart from just a general objection, you're not going to get up there and try to make the case for the other party as to what the deficiencies are, right? I mean, that's really not what's expected, is it?
I think, yes, Your Honor, it's not expected at trial, but I think in the situation where there was a pretrial conference previously in April, there was nothing from Mother's counsel stating that any expert that was proffered by the department wasn't qualified. And yes, they went through the voir dire, and yes, the voir dire itself could have been cleaner, but again, the papers, meaning expert Betancourt's CV, obviously showed that she had qualifications. Maybe there was not testimony during voir dire that her qualifications were exactly on point, but I would also turn the court's attention to custody of Michelle, in which experts who are CASA volunteers or court special advocates have been qualified as experts who are able to...
Is that an Indian Child Welfare Act case?
No, Your Honor, it's not an ICWA.
So, I mean, don't the cases all say that something more than the qualifications of an ordinary social worker are required?
I think, Your Honor, what I tend to focus on in terms of the ordinary qualifications something more, the idea that this particular expert had an expertise in Native American culture and traditions, given her background, her education, and her history, when I combine that with what I read in the 2016 guideline rules, where the Department of the Interior states that the final rules still provide state courts with discretion to determine what qualifications are necessary in any particular case.
Right, but the regulation says that there has to be an expert qualified to testify about the likelihood of harm to the child. And the legislative history in the cases suggests that that person, and then you can have an expert about Native American traditions and culture. You don't have to. But on the first part of it, that person has to have qualifications beyond that of an ordinary social worker.
And in this situation where expert Betancourt worked as a guardian ad litem, she had experience in child welfare practice. She's something beyond a social worker who would be able to testify to best interests in our normal cases, but in an ICWA case, the best interest also hinges upon substantial harm. That is something that if someone was writing a guardian ad litem report, say in the probate courts, they would be able to suggest that a particular custodial type of arrangement is contrary to best interest because it substantially harms the child or could substantially harm the child.
So, I think the mother's response would be, even if you were right about that, where she didn't even meet the mother once, that she's really relying on the department, and the department can't come in and give this testimony.
I think, Your Honor, to address the lack of meeting maybe with my client and/or mother, there is testimony that was given by expert Betancourt that I believe was cut short by mother, in which she said, I met the family, or I met them, meaning my client and the tribal foster mother. So that testimony was not necessarily extracted by mother at trial, and it wasn't followed up with the department's counsel at trial. However, in terms of methodology, and we are talking about methodology, then I would refer back to what I had previously stated about some type of a hearing as to methodology, meaning a Daubert-Lanigan type of hearing, that is this expert conducting themselves in a particular manner. Otherwise, I would argue that to the extent that the trial court first qualified her as an expert and then she was qualifiable on the papers, that because there was no objections raised at the trial court level, that would be waived upon appeal.
Do you think we should wait until the Supreme Court rules?
So, Your Honor, in terms of what is pending before the Supreme Court, my understanding of that particular case is that it is focused in on placement of children, meaning...
No, I thought there was an anti-commandeering issue there, dealing specifically with both active efforts and the expert requirement.
The part of the argument that I was able to listen to, the 3 hours that I got through, there were Article 1, Article 3 concerns that were brought up, and I believe that the petitioners or the plaintiffs in those cases were primarily focused on placement priority.
All right, let's say these two provisions are under review by the Supreme Court. Do you think we should wait until they rule?
I think to the extent that ICWA is a minimum standard, if this court felt that the application, given the history of ICWA, if it is repealed, I think that this court could potentially lower the standard and support the judgment, maybe not particularly under the guidance of ICWA, but under our regular ordinary course of termination cases and under our underlying statutory scheme for termination.
Let me just ask you this kind of along those lines. So we have a federal statute. Would you agree that creates a higher burden, proof beyond a reasonable doubt, correct?
Yes, Your Honor.
Than under state law?
Yes, Your Honor.
And that's applicable as the statute refers to them as Indian children?
Yes, Your Honor.
Correct? So am I reading it correctly? In sort of a perverse way, the federal statute that's designed to protect family integrity of Indian families can result in those children being placed in an environment that non-Indian children might not have to be placed in.
Yes, Your Honor. My understanding of ICWA is that it is a remedial statute wherein, to the extent that Indian children were previously removed from tribal homes and placed in non-tribal homes, decimating the tribe's populations, ICWA was intended to rectify as a remedial statute, and it has a preference of placing Native children with Native families. Whereas here, the department did meet that burden to the extent that my client is now with a tribal foster mother. So they did recognize that preference.
Right, so that's my point. So in other words, DCF may meet its burden under the clear and convincing standard for a similarly situated non-Indian child, but not meet its burden under federal law under the reasonable doubt standard for an Indian child.
Yes, Your Honor. However, we are arguing that they did meet their burden.
Do you read Section 1914 to allow for collateral attacks on a termination decree?
One of the concerns I have and one of the questions I pose is whether or not ICWA can be an absolute defense to termination by a parent. So to the extent that there's collateral attack ability, I think it is drawn backwards a little bit by the regulation and the guidelines, which again, don't intend to usurp all state authority in terms of family law, child welfare cases. I think it's to again, the goal is the remediation to make sure that a child is not pulled away from a native family. And here where my client is still placed with a tribal foster parent who is part of a Wampanoag tribe, I think that the department has done what they needed to do under ICWA in terms of the overall goal of ICWA. I don't think it was intended to allow cases to perpetuate in an ongoing basis where a child is basically, it somewhat defeats the purpose of the Adoption and Safe Families Act. I don't think that that was the intent of ICWA, to undermine that, where my client has now been in foster care for almost 6 years. I think it'll be 6 years this March. So here's my client, and when I look at Adoption of Knox, which came down, which talked a little bit more about how children who are left without stability, without certainty, and are in a foster home not knowing what is going to happen in their future, I don't believe that the intent of ICWA was to undermine the idea that we're promoting children's welfare and making sure that they are in a stable, loving home environment as soon as practicable.
Thank you very much. The case is submitted.
Thank you, Your Honors.
The fifth case today is 2022-P-737, Luis Pedrosa versus Sentinel Insurance Company and another. I believe that we're going to hear first from William Federico for Hanover. I don't know what you agreed. I'm looking at the sheet I was given, so. Do you want to confer for a minute and make sure you're on the same page? And I take it you're Mr. Rockus?
I told clerk to send me an email. I would go first, have 7 minutes, and the sheet gives Mr. Federico's 8 minutes.
Are you all set then with that, Mr. Federico? Yes, that's fine. Okay. All right, so we're going to hear first then from Attorney Rockus, correct?
Yes, Your Honor.
Excellent. And you'll have
Your
7
Honors,
minutes.
my name is George Rockus. I represent Sentinel Insurance Company, and with me is my associate, Ann Kim. There are 2 issues in the case. Two issues for Sentinel, whether the auto exclusion bars coverage. That's not an issue for Mr. Federico's client, Hanover. The second issue is a common issue. Did the accident that's at issue in this matter arise on a leased premises? I'm going to deal with the auto exclusion first. If time permits, I'll lay the table, or set the table for Mr. Federico on the lease issue. It's interesting that this case is an odd case, because usually motions for judgments on the pleading aren't used offensively. They're used defensively by a defendant. And why is that? It's because the plaintiff can craft the allegations in such a way, whether true or untrue, and say, well, the complaint says X, so I'm entitled to judgment on the pleadings. Here, it's important to note that Sentinel denied that the auto exclusion applies in its answer. It also denied that the premises was a leased premises. And if you look at the auto exclusion, and we're really talking about whether paragraph 2 of the auto exclusion applies, because it says this exclusion applies even if the claims against any insured are like negligence or other wrongdoing in the supervision, hiring, employment, training, monitoring of others by that insured, if the occurrence which caused the bodily injury or property damage involved the ownership, maintenance, or use or entrustment of an auto. The key word is maintenance. And I know that the test is articulated in the first specialty case, which basically says that if the second paragraph applies, there is no coverage, and it's a two-pronged test. The paragraph excludes coverage if the claims are brought against any insured alleging negligent supervision or hiring of others by that insured, and the occurrence underlying those claims involved an automobile owned or operated by any insured. Here, it's clear the automobile was owned by an insured, Mr. Sperry. So the issue is, are the claims brought against any insured alleging negligent supervision of hiring of others by that insured? And the answer is yes. Why do I say that? If the complaint, that is the complaint brought by PEDROSO against the insurers.
Which we don't have, by the way.
Yes, you do.
We do?
The complaint brought by PEDROSO by the insurers, that's the,
Oh, I'm sorry, I mean the underlying complaints.
you do.
We do? Okay.
And it's actually in a supplemental appendix.
Supplemental appendix, okay.
And the.
So, but when you talk about, well, I don't want to interrupt your answer. When you talk about the auto, whose auto do you mean?
It's the pickup truck driven
Sperry's.
by Mr. Sperry that basically backed up the wrong way and hit Mr. Slattery and Mr. Stevens, killing Mr. Slattery. That's the auto, and he.
So you're not talking about some other auto like that the trust didn't properly
No,
supervise
no.
the snow
Yeah,
removal company?
And that auto was owned by Mr. Sperry. That's uncontested. The complaint, that is the coverage complaint, the complaint brought by PEDROSO against the insurers references what this case is all about. It's the case of Slattery versus Northeast Form Engineering, PEDROSO et al. They don't attach the complaint to the coverage complaint. That is, they don't attach the Slattery complaint. But I think this court can look at the Slattery complaint to see what it says, since it's referenced in the coverage complaint. And in paragraph 10 of the Slattery complaint, and that's in the supplemental record appendix, reads, this case arises out of tortious injury and death caused by defendants PEDROSO, Torres, and Brinks through their ownership, operation, here's the key word, management, maintenance, and control of the premises.
The key word seems to be premises.
Key word is management.
It's premises is the key word, right? I mean, the claims against the trust are, have to do with the failure to maintain the premises in safe condition.
Well, it's also, according to this, failure to manage.
But they're not saying that the trust negligently hired or supervised Sperry when he decided to tow this tractor trailer out with his truck, right?
That rationale would only apply if, in paragraph 1, but there's if the severability, but any means any, if it's any insured, and here that any insured is Sperry. And what I was going to say is management, that's in paragraph 10 of the Slattery complaint. If you look in the dictionary, you can look in Webster's, Merriam Dictionary online. I looked at the 1975 Webster's Dictionary I brought when I was a freshman in college, and it's equated management with supervision. So you meet the language of the second paragraph. So therefore, the exclusion applies, and it bars coverage. And again, the complaint in Slattery is in the supplemental record appendix.
I see it now. I see it.
You got it, yeah. And so that's very clear, because management equals supervision. You can go online, look at the Merriam-Webster Dictionary online, or I can give you my 1975 version of Webster's, which I have copies of here.
Well, I guess, I just don't understand. You're saying that it's paragraph 2 of the auto exclusion that makes this not be covered?
Yes.
And what is it? Because that says, it says maintenance, use, or entrustment to others of any aircraft, auto, or watercraft, but the property owner did not put any automobile in the hands of Mr. Sperry.
No, but it's, if you read Marnell in first specialty, it draws a distinction between the severability of insured's provision. Any in the second paragraph means any. It doesn't just refer to Pedroso. And here, the bodily injury or property damage was caused by the operation of a motor vehicle by Sperry, who is any insured.
So you're saying as long as the injury was covered by an automobile, then nobody gets coverage?
If it's any insured, right. And that second paragraph was purposely put in there if you read the history. Because if you read the Marnell case, they said any doesn't mean any. It means they applied the severability provision. A severability provision is a provision in the policy which says you treat, you analyze coverage as if each insured was issued its own policy. Then after Marnell, they added paragraph 2. And again, it's the first case I cited, excuse me, Your Honors, the first specialty case, which applies paragraph 2. It gives you the roadmap.
So if the trust were sued because they didn't plow the road, and because this truck caused this injury, you're saying there's still no coverage?
Yes, because the truck was driven by any insured. And that's correct, Your Honor. That's correct.
Okay. And are you arguing separately that Mr. Sperry was acting in his personal capacity and not as an employee of Northeast?
Well, he was. I mean, if you look in the record appendix, something.
But is that are you making that as an independent reason why your client does not owe insurance coverage?
Well, no, it's a reason why Pedroso is not my client. Pedroso isn't entitled to insurance coverage. In the brief of Pedroso, they keep on saying that Mr. Sperry was acting in the course of employment. They say that repeatedly. However, in the litigation, underlying litigation, and there's amended findings of fact which are in the record, it says there was a finding by the court that Mr. Sperry was not acting in the course of his employment when the accident occurred.
What I'm trying to understand is are you saying that that is an independent reason why there's no insurance coverage either for Northeast or for the...
Only reason I raised it, and the only reason I raised it in the reply brief is because Pedroso raised it and was trying to say, well, if Mr. Sperry was an employee of Northeast when the accident occurred, he should be entitled to coverage under Northeast policy. And I'm saying, well, no, the court found in the amended findings of fact and conclusions of law that Mr. Sperry was not acting in the course of his employment when the accident occurred. That's part of the record. That's why I raised it. If that issue was never raised I never would have raised it in the reply brief. I only raised it because...
Who is the real plaintiff? Is it Liberty Mutual?
Well, there were two plaintiffs, but there was a lawsuit brought by Mr. Slattery. He died.
No. In this coverage case, is the real plaintiff Liberty Mutual?
No. Well, yes.
When you were negotiating the judgment, were you negotiating with Liberty Mutual?
Well, I negotiated with Mr. Pierce, who was retained by Liberty Mutual.
And is that Liberty Mutual, or are you negotiating? Why is the trust entitled to any money? You'd be negotiating with Liberty Mutual, right?
Well, because they're bringing a subrogation action. Mr. Pierce was retained by Liberty Mutual.
I'm asking. Okay, I'll ask your friend.
Yeah, I mean he knows the exact relationship. But if you read Marnell and read the first specialty case,
I think you're over 4 minutes over time.
Okay,
so I think we understand. I'll just make sure
it's
nobody
actually,
else.
I think I had
Okay.
7 minutes, but.
You've already had your whole 7 minutes and
Okay,
another 4.
I apologize. I will sit down. Yep, thank you.
Good afternoon, Your Honors. William Federico for Hanover. and I'll be addressing the insurance coverage issue that applies, I think, both to Hanover and to Sentinel, and that's whether the landlord, that is the trust, is covered as an additional insured under the tenant's insurance policies for this incident which occurred on a common area. It's undisputed that it occurred in a common driveway. And
Having a little trouble hearing you.
Oh,
Could
I'm
you pull
sorry.
the microphone up?
Does this microphone magnify or amplify? And so critical to that question is this question. Was the common driveway a part of the leased premises? If the answer to that question is no, then there's no coverage, because the coverage is only with respect to the leased premises.
So the leases say that the lessee hereby leases the following described premises. That's in paragraph 1.
Correct.
And then in paragraph 2, it describes the premises as including the individual units together with the common area and parking. So why isn't that just plain that then those two things together are the leased premises? Just one is not exclusive.
Well, what it says, Your Honor, is it says the premises that are being leased are a portion of the entire premises, which is the commercial location at 44 Stedman Street in Lowell, and there's 14 tenants. And specifically, each tenant gets a unit. So my client, or my insured, Ducan Brewery, leased Unit 4. The paragraph also states that, yes, as a tenant, you have the right to use common areas. In other words, you have to be able to come and go to your unit. Having Unit 4 without being able to drive to it or use the parking lot or driveway or the hallways for that matter or the staircase would not be much use. So it does spell out something which I think is superfluous, but it says, yeah, you have the right to get here. You can use the driveway. You can use the parking lot. But it's not saying that you're leasing it. A lease implies that you have exclusive possession of it to the exclusion of the world, even the owner. Here, none of the tenants have any possession or control over this common driveway. They're allowed to use it just as any tenant
Are
can
you
use it.
saying the law prohibits someone from saying, I lease you this ability to share in this common area?
Not exactly, Your Honor. I think the law would prohibit what the trust is suggesting, which is that all 14 tenants were leased the same driveway. I don't think that's permissible. You could lease a portion, but you can't say to somebody, you have the right to use this piece of property, but I'm not granting you any interest in the land. I'm just saying you can use it together with 14 tenants. You have a right of common use. That doesn't create a lease. There's a difference between a lease and a license.
Let me ask you this. So when you have the trust in preparation for these leases, the trust goes out and they procure their own insurance, and then as part of each individual lease agreement with the tenants, they require them to acquire insurance as well. Do you think that that trust, at that moment, is thinking that, well, there's going to be parts of this property that aren't going to be covered by any insurance at all?
No, I think the trust, as the owner of the land, is thinking, we have insurance, it's going to cover us, and for example, it'll cover us for common areas, like the driveway, but we want to make sure if incidents occur on the leased premises that we don't have the same control over, because we're giving them to the tenant, that the tenant will make us an additional insured for incidents in the leased premises. So in other words, the trust is saying, well, we should get duplicative coverage. We should get our coverage, and we should get the tenant's coverage. And really, and Judge Gantz gets into this in the Gillis versus DeMarco's case, he says what the parties are expecting is not that they're creating duplicative coverage, but that the landlord will be covered when there's something that happens on the leased premises. So that's something the tenant agrees to provide to the landlord. But the landlord here is, in a sense, trying to double dip.
Right, but if we accepted your argument and Northeast created some sort of hazard in the driveway, like let's just say they spilled a box of ball bearings and somebody fell and got hurt,
Okay.
would Northeast have coverage under your policy if we accept your argument?
Well, yes, Northeast
Sounds
is,
like no.
No. Hanover insures. if they dropped ball bearings. Well,
Because you're saying, you're
well,
only,
well,
what I'm understanding you to say is you only insured the leased premises, so you are only covering your northeast for what happens inside the unit northeast.
right, as an additional insured, we are only covering the trust for incidents that happen on the leased premises. If something happens in the driveway, it's not covered. It's covered by the landlord's insurance.
Why would it be covered by the landlord's insurance?
Because that's what they have commercial liability insurance for incidents that occur on their
Don't
property.
you define that as something like the unit?
Well, no, it would be the trust has insurance for its entire property.
I'm not talking about the trust. I'm asking if your interpretation would leave Northeast without insurance coverage in the event of a very foreseeable situation.
I may be confused by Northeast.
Okay,
Hanover's
then Ducan, it doesn't matter.
Sorry.
It doesn't matter.
Oh,
Ducan,
yes,
any of the tenants.
Yeah, okay.
If you're saying you only are covering anything in a unit, then how is Ducan covered if something happens in the driveway?
No, because Ducan's coverage with Hanover is not limited to what occurs in the leased premises. That's a limitation on the additional insured coverage, Your Honor. So for the landlord, there's a limitation that's different. The case law in Massachusetts is quite clear that it distinguishes between leases and licenses. A lease is an exclusive possession of property, like I said.
But you can contract, or, I mean, you can say this is the lease premises.
You can.
Right.
In one court, recognize that. The Norfolk and Dedham versus...
So let's say we find this lease ambiguous. You say it has to be construed against the trust because they're the drafter of the lease.
Correct.
Well, first of all, this isn't an action between the parties to the lease, right? And we have cases that say...
But they're standing in the shoes.
Well, but we have cases that say in the situation where there's an uncertainty in insurance coverage, that's construed against the insurer. So how do we reconcile that with your contention that we have to construe the lease against?
Well, because the lease is the determinative document here, Your Honor, and that'll determine what the coverage is triggered.
When the policy is underwritten, I presume the lease is provided, right?
I honestly am not sure whether it was provided to the insurance company. It may have been. I don't know.
Well, so they choose to insure additional insured without looking at the lease? Don't they have to see what they're insuring?
I assume it most likely was, but I'm not absolutely positive.
So then why aren't ambiguities resolved against the insurer?
Well, the ambiguity is not in the insurance agreement. If there was an ambiguity in the insurance agreement, I'm following Your Honor, and yes, that would be applied against the insurer. But here the ambiguity is in the drafter of the lease, and the drafter of the lease is the trust. And
But isn't the
Liberty
time
Mutual
for the
standing in the
insurance
shoes of the
company
trust.
to raise that at the time of the insurance, when somebody can do something about it?
Well, Your Honor, if I could, the drafters of the trust, I'm sorry, the trust as the drafters of the lease could have easily made this situation go away, as they did in that Norfolk case. In that case, the lessor, the landlord, said, you are leasing the unit and you're getting 15.4% of the common areas. And then they even went further and they said, and common areas for purposes of additional insured coverage will include, are part of the lease premises. So if the trust wanted that sort of coverage, that's the way you have to draft it.
Yeah, but
the way they drafted it here.
they're doing the 15.4% to apportion property taxes. We see lots of cases with that issue. And nobody's saying, oh, well, they had this 15.4% of the driveway, but the accident happened on the other 4.6% of the driveway. So they're saying, basically, you have an undivided interest in the whole. It's just that we're giving you a certain percentage so we know how much to charge you for taxes.
But the tenants don't have any interest in the whole at all. All they can do is use it to get to their unit. It's a right of use, not a lease.
So you say, you're looking at other paragraphs in the lease, and you say, well, one resides in a building, not in a driveway, and so there's no reason the lease would prohibit residing in the driveway. Well, what if your client parked a mobile home in the driveway and was living there?
I hadn't thought of that, Your Honor. I imagine the landlord would say, well, what are you doing?
You can't reside in the driveway.
What are you doing in our driveway living there? That's not allowed. And I know I've gone over my time, but I'm happy to answer any other questions.
Any further questions? Well, we understand your argument. Thank you very much.
Thank you very much.
Good afternoon. May it please the court, Robert Pierce for the PEDROSO Trust.
Are you representing Liberty Mutual or the trust?
Well, you asked a great question. I talked to clients. So when I get hired by an insurance company to represent one of its insureds, my first client is the insured, PEDROSO Trust. So I sign pleadings. I go to court representing PEDROSO Trust. Liberty Mutual pays me.
They're not getting the money, right? It's
No.
Liberty Mutual that's getting the money.
Absolutely.
Is this a claim for contribution?
I would say it's a claim for indemnity and defense costs.
So the money that was agreed upon in the judgment, the 33% each, that's going to Liberty Mutual.
It is.
I find this very perplexing that the name of the real party in interest can be hidden from the court in this way. I mean, right, so the appellate rules require corporate disclosure statements so we can ascertain whether we have a conflict of interest. And if we don't know who the real party in interest is, how do we do that?
Well, that's perhaps an error if we didn't disclose that, Your Honor, but I think it's pretty clear in the Superior Court's decision that Liberty Mutual settled the cases and paid for the defense, and that the payments were going to be apportioned on the judgment, one-third, one-third, one-third.
Right, to the trust. So, I mean, you read this record and the briefs, and it appears for all intents and purposes that the party suing is the trust. And, you know, we don't know if we have a financial interest in a company when it's not disclosed as the real plaintiff.
If it's not disclosed, we should have disclosed that, Your Honor, but I would say that this is not an unusual situation and not an issue raised.
Well, normally, at least the court is made aware. I mean, the rule is there to avoid prejudice in front of the jury, right? But I mean, but you're representing today that the money is going to Liberty Mutual, right?
That's correct.
Okay.
Would it go first to the trust and then to Liberty Mutual?
The check would probably come to me and I'd send it to Liberty. It probably would be made out to Liberty. They might even pay it directly.
All right, so their big argument on the insurance coverage is this was a license of the common areas, it wasn't a lease of the common areas, and why are they wrong about that?
This is fairly simple, and I think one of your honors hit the nail on the head earlier. It's actually very simple, and Judge Barry Smith seized on this in the lower court. The last sentence of paragraph 1 says, "Lessee hereby leases the following described premises, colon." Then it has a big, all caps, premises. So this is a defined term, which taking paragraph 1 and 2, you have leased premises, and it goes on to say a portion of the premises, along with the right to use in common with others, entitled thereto the common areas for ingress and egress. So the defined term, and I don't want to go into patent law because we don't do that in state courts, but the parties can be their own lexicographer. They can come up with their own terms. There is common law out there that suggests, as the plaintiffs do, the appellants do, that a lease is for exclusive use. But in this case, a lease is not for exclusive use because the term they came up with, premises, includes common areas, and there is no one here arguing that the back alleyway where this tragic accident occurred is not an area used for egress and ingress. And so when the insurers, and that's the two defendants, when they say, we'll insure you for the leased property, well, that's really only in the Sentinel policy. The Hanover policy deals with property you lease, rent, or occupy. And we have made that argument. At the time of the accident, the tragic death, the only employee of Hanover's insured, Ducan, Mr. Slattery, who was killed, was occupying that alleyway. But the more important thing is, as you listen to and read what Judge Barry Smith said, it would be nonsensical to say, oh, listen, we'll cover the trust for accidents, but only within the unit. But we're not going to cover it if they're out doing something they're allowed to do and cause a tragic death. It just doesn't make any sense.
But what do you say to the argument by the appellants? If the if this alleyway or driveway, whatever it's called, if it's not even maintained by Northeast or Ducan, and it's maintained, especially in this instance, we're talking, you know, snow removal seemed to play a factor in this whole tragedy. If that's a responsibility of the trust, isn't there some force to the argument that, well, if Northeast and Ducan aren't responsible, then why should their insurance companies bear any responsibility?
Separate and distinct issues. So the indemnity agreement between the lessee and lessor is one thing. The insurance agreement whereby the two insurers agreed to defend and indemnify my client is a completely separate and distinct issue. The maintenance of the driveway is a red herring. The insurance policies say nothing about who is going to maintain the leased premises. They say nothing about that whatsoever. It's simply they're going to defend and indemnify if the action or the injury occurred on the leased premises, which is defined right in the first paragraph and second paragraph.
Well, Article 10 does place responsibility for snow and ice removal from the parking lots surrounding the leased premises on the trust. And their argument, I mean, unless you disagree with that, in which case I definitely want to know that, but their argument is that that is that's distinguishing then leased premises from common areas. So what do you say to that?
I say that, as Judge Barry Smith said, he goes through on page 8 of his decision about 10 different provisions where the term premises or demise premises are used, and it would apply both to the unit and other areas in which they can use that are common. There are a handful that would be exclusive to, for example, the heating of the unit. Obviously, we're not going to heat the outside. I don't think they did. So, but I think it's a little sloppy in those paragraphs, to be perfectly blunt. But I would say that, as Judge Barry Smith said, paragraphs 1 and 2 and the definition and the defined term there trump those slight sloppy terms. I'd like to turn to the auto exclusion unless you have more questions on this issue. But before I do that, I do want to just point out to the court, and it's an unpublished decision, but it's Norfolk and Dedham versus Morrison. It's directly on point. In this case, it says the insurance policy in favor of the landlord as an additional insured says liability arising out of your ongoing operations or premises owned or rented by you, the tenant. That's what's covered. And in this lease, it said that the tenant was leasing premises that include both her interior space and 15.4% of the common areas. And therefore, this case is directly on point because what it does is, it says, if you define what's the leased premises as common areas, accidents in the common areas are covered under these additional insured provisions. Turning to the auto exclusion.
Before we get to the auto exclusion,
Sure.
the occupy part still applies to whether there's coverage at all, right?
I think so. Well, if you find that they leased the premises, then both are on the hook. If they didn't lease the premises, I still think we can get Hanover on the occupy.
Okay.
So it's a two-step process. It's belt and suspenders. You don't need both. The auto exclusion, Your Honors, it just doesn't apply. The history is a little bit tortured, but the Marnell case came out. The insurers were not happy because a person who was accused of negligently supervising or loaning a vehicle, that was covered, and they didn't want to have that happen. So they put in this second paragraph that basically says if you are supervising someone who's in an accident with a vehicle, that's excluded by the auto policy. There's no exclusion for negligent failure to remove snow. And I think the cases
But he's saying that the whole charge here of negligence related to the use or somehow involved an automobile. If it in any way involved an automobile, then there's no coverage. And he's saying that's what that second paragraph tells us.
Well, it's not the way I would read that, Your Honor. It's because it goes directly, it says, it's long, but it says the exclusion applies even if the claims against any insured, and by the way, any insured, so with the separation of insured's provision, any insured includes the Pedroso Trust and Pedroso's employees. It does not include Sperry because it applies separately there. And you would see that in the first specialty case, First Specialty versus Pilgrim. But it says the exclusion applies even if the claims against any insured alleged negligence or other wrongdoing in the supervision, hiring, employment, etc., by that insured. And it goes on, and this is the second condition. If the occurrence which caused a bodily injury or property damage involved the ownership, maintenance, use, or entrustment to others of aircraft, auto that is owned or operated by or rented or loaned to any insured.
Okay, so you're putting in some numbers in there, like you're saying conditions, right? So where do those numbers go if we were to?
All right, so I would say it's two-part. Start with one at this exclusion.
Yes, and then the two is if the occurrence?
Yes.
Okay.
In other words, and reading from the decision in the Superior Court, and this is quoting from the First Specialty versus Pilgrim case, and here's the test. Thus, for each defendant in the underlying litigation, we must determine whether, according to the complaint, that defendant negligently hired or supervised another insured person who owned or operated the automobile involved in the occurrence. The answer is no, we didn't. We're accused in page 14 of the underlying complaint of doing a lousy job clearing snow and ice.
It's the same language, right, that was at issue in First Specialty? The
That
language
is.
is identical, right?
Identical. It's identical. One final point. I think the court is aware of this, and I'm not sure that Sentinel is arguing this, but the argument that at some later date at trial, Mr. Sperry was determined to be not in the course of his employment, it's a red herring. Because you look at the complaint as it was filed, you look at the insurance policy at that time, and the complaint, when it was filed, was very clear to say that Mr. Sperry was in the course of his employment. That's what triggered coverage. The fact that 3 years later, well after we settled, that was proven not to be the case is just irrelevant. And if the court has no further questions, I'll yield my time, as they say in Congress.
Thank you very much. The case is submitted. Very helpful argument. Okay, we're up to our last case of the day, which is 2022-P-467, HACHE versus Wachusett Mountain Ski Area, Inc. Whenever you're ready, counsel.
Good afternoon. My name is Jeff Rafelson, and I represent the plaintiff appellant, HEIDI HACHE. The civil justice system cannot function if litigants behave like Wachusett did in this case. It was a fabricated training record, interrogatory answers and document production responses directing the plaintiff to those fabricated records, the implication of Wachusett's attorneys in the fraudulent scheme, and perjured 30B6 deposition testimony to cover it up, present a classic, near classic case of fraud on the court under Rockdale and Aoud. This court
in HACHE 1 posed the question, is this misconduct attributable to WACHUSETT or its CEO, Jeff Crowley? And the answer I submit is resoundingly yes. In light of the evidentiary hearing, there is now compelling evidence that WACHUSETT ratified the scheme.
Well, but we're not deciding this in the first instance on our own, so you need to show us an error of law or a clearly erroneous fact.
Absolutely, Your Honor, and the error of law or clearly erroneous fact was that WACHUSETT timely remedied the fraud after it learned about it. And that's clearly erroneous because it's undisputed that WACHUSETT did not take any step to disavow the fraudulent scheme for a full year, and that the law required WACHUSETT as Feely's employer, who committed an obvious unauthorized act on behalf of WACHUSETT, that WACHUSETT had a duty either to remain silent and acquiesce in its employees' fraud, or to promptly disavow it. And it could not.
I want to be clear, though. So this theory that you're advancing, right, that this delay of a year, that basically does not challenge or assumes that WACHUSETT didn't know and it was finding this out when you were finding this out.
I have to accept I think that the court and I have to accept the judge's finding that before Feely testified, WACHUSETT didn't know about the fraudulent scheme. But I do say, and I say at beginning at page 47 of my brief, that there were enough facts to create a duty of investigation on WACHUSETT to determine whether or not the certified training record that's that issue in this case was actually fabricated.
All right. Well, this kind of goes right to what I was going to ask you about. But first of all, they are extraordinary facts, and I think by any review of this, it was an extraordinary amount of work that kind of unmasked it all. But here's the problem. How do you get around Judge Kazanjian's crediting Mr. Crowley's testimony? I mean,
Mr.
entirely credited it. So it's kind of hard to get past that, isn't it?
I don't think so. I don't think so. I mean, as I said, I concede that her ruling that WACHUSETT didn't know of the fraud before Feely testified is entitled to deference. But now the record is crystal clear. It's in black and white, right? There's all sorts of documents that demonstrate it, that WACHUSETT learned about the fraud. And this is my case, right? WACHUSETT learns about the fraud. And the law of ratification is crystal clear that WACHUSETT, as an employer of an employee who commits an unauthorized act on behalf of the employer, has a choice at that point. And that choice is, I accept it. I'm the employer, and I accept this fraudulent conduct or this misconduct. And I acquiesce in it, and I remain silent about it. And I certainly don't try to benefit from it, because that's what they did in this case. And I want to underscore that.
I want to unpack that. Okay, so, and I have two questions particularly about it. So, as you are doing the very excellent job you did to uncover the fraud, counsel for WACHUSETT is learning the same thing you're learning, right? So, by the time you've learned, beyond really any doubt that Feely's falsified the records, that's also the same timeline for WACHUSETT, right? So there's not a period where they know but you don't.
I believe that's true. I believe that I brought it to their attention.
Okay, and what I'm understanding is you're saying they tried to benefit because of what Attorney Sweet put into a mediation statement, correct?
I am.
But at that point, you knew too.
Absolutely, but it didn't deter them. It didn't deter them from trying to gain an advantage.
Was there anything else besides the mediation statement? Is that what is in terms of Attorney Sweet's participation?
There's 2 points.
Okay.
The first one is that the law is crystal clear that they had a duty to disavow it promptly. That's point one. They can't get around that. It was a full year before they took any step to try to disavow it. And during that full year, at the 6-month mark, Mr. Crowley actively participated in the fraudulent scheme when he approved the mediation memorandum, the mediation overview that set forth the strategy.
But you have to prove it hampered the presentation of your claims or the adjudication of the case. And the judge found you hadn't met your burden.
Well, that's a different issue. What I would say about that is that if the court finds that Wachusett ratified the fraud, which I'm saying is dependent upon 2 facts, right? The failure to disavow it for over a year, and then the active participation in it by approving the mediation memorandum that set forth the false narrative that Wilson
They say it's not false, that in fact the employees were properly trained. He just didn't receive the online training.
Well, if the Wachusett required its lift attendants to go through this training and thought it was appropriate, I think that's what proper training is.
As Justice Henry pointed out, you knew during the mediation that the employee gave false testimony.
I did.
Okay, and they also knew, and they knew that you knew, so
yeah,
how was your
it's remarkable,
case hampered?
Right? It was hampered. So if the court finds that there was a ratification of the false testimony and this fraudulent scheme, then it relates back, and it's as if Wachusett had approved it from the very beginning, right? That's the clear law.
I don't understand why we're talking about ratification, to be honest, right? I mean, we're talking about fraud on the court, and there's a lot of discussion about what happened outside of court. Did he discipline him? I mean, why do we care what happens outside of court?
I hope that the court cares because,
these
are circumstances where a corporation learns about acts of its employee that amount to a fraud on the court.
But why do we care what happens outside of court?
It doesn't, I mean, Rockdale happened outside of court. Ayoud and Rockdale happened outside of court.
Those are not fraud on the court cases.
Those are fraud on the court cases that involve a fraudulent scheme in the context of discovery or in the context of producing a false document that is used to benefit a party.
But okay.
So it's not.
Why do we care, for instance, whether Wachusett fired him promptly or not? Why does that matter?
Because that shows that they acquiesced in the conduct. Because the court in Pinshaw, the court said that that's a factor that you can consider as to whether or not the employer or the party in this case acquiesced in the fraudulent conduct.
But I'm not, okay, obviously we don't want any fraudulent evidence ever before a court. We do care about that. The question though is, you're giving this narrative about why they didn't fire him, and I'm thinking it's perfectly logical that they didn't fire him because he's already proven himself to be a scoundrel and a liar, and at least this way I have some kind of control over him. If I fire him and now he's an angry scoundrel and liar, gosh knows what he might go to you and say.
Well,
I mean, that to me is the more logical reason, not to mention he has a wife who also works there and a baby on the way. That's a whole other category.
Well, they actually refused to answer the question as to why they waited the 21 months, left him on as the head of lift department training with responsibilities for skier safety, promoted him to additional responsibilities for skier safety, and didn't discipline him in any way for 21 months.
But we're back to a factual finding from the judge, right?
But the factual finding from the judge is clearly erroneous, Your Honor, because it is premised, it is entirely based upon and she said this on multiple occasions, that Wachusett timely responded to the fraud once it learned of it. That's my case, that finding.
All right, well, on that point, let me ask you this. When I'm thinking of fraud in the court, I'm thinking of, as the Supreme Judicial Court has said, you know, bribery of judges, bribery of juries, something of that nature. It has to be really egregious conduct, and it has to really strike at the heart of the judicial process. So if you learned of conduct on their part that was fraud in the court, presumably you'd have some kind of obligation to bring it to the attention of the court.
And I
right?
did, ultimately.
All right, but you didn't bring it to the attention of the court right away, right?
No, I didn't. I didn't bring it to the attention of the court right away. And it wasn't until we got near the trial that I brought it to the attention.
So doesn't that tend to diminish the theory that it's a fraud on the court? Because if it really was a fraud on the court, I would think you'd be running into the courthouse and saying, Judge, you've been defrauded. You know, stop the presses. But that didn't happen.
Yeah, I understand that, but the issue is whether or not this tracks Rockdale and whether or not there was ratification by the employer, by the party, of the facts that gave rise to a fraud in the court that track precisely, virtually, Rockdale. And I would say one other point, which is that in Winthrop versus Lowenthal, the court said that fabrication of evidence by a party in which an attorney is implicated will constitute fraud on the court. That's a quote. Wachusett's attorneys were implicated in the fraud on the court. They were implicated at the beginning when they signed interrogatory answers and they directed us to the fabricated record. When they filed a pretrial memorandum in which they said that all employees were properly and completely trained. And then finally, when they went through this, when they developed this mediation strategy to perpetuate the false narrative in the mediation, and I hear what you're saying, I knew about it, but that didn't stop them from doing it and trying to get a lower settlement by insisting that they were not responsible for the accident and that Alex was responsible for the accident, that he was contributory negligent. And what I submit to you is that if they had come clean, they wouldn't have that argument. They wouldn't have had the ability to say that the settlement should be less because your client was partly responsible for the accident.
Do you have a case that says that what happens in mediation or settlement discussions can be fraud on the court?
No, Your Honor, and it's not, and I'm not saying that what happened in the well, I am saying that the advice of the counsel, I'm not saying it happened in mediation. It happened outside of mediation. There was a mediation overview that was sent from Wachusett's counsel to Wachusett. And because they waived the attorney-client privilege, that came to me, and I saw that. But that was not in the mediation. And so ZVI, the ZVI case, which they cite to, is inapplicable because there's no protection for statements made outside of mediation. And so, yes, I think that these statements are very important to my claim. They're important to my claim because it shows that Crowley knew that the lawyers were not disavowing the fraud 6 months after he learned about it, but they were perpetuating. So there's no reliance on counsel.
But the perpetuating it is that they're saying that the guy was properly, the lift operator was properly trained?
That's right.
Right, and I think the distinction that they're going to draw is that the online training was extra training, but that the base minimum was covered.
And in the mediation memorandum, they actually state that their training consisted of 2 key elements. One was the online training, and one was the hands-on training.
Okay.
And if they required it, then that's what was proper and appropriate, number one. And number two.
And the statement was outside the mediation because it was between the lawyer and the client?
And it didn't go to the mediator. Or it went to the mediator separately.
Well, if it's just between the lawyer and the client, I'm missing where the fraud is on anyone.
It just evidences. It evidences that Crowley didn't rely on counsel,
Okay.
right? It evidences that they approved a strategy, that Crowley approved a strategy to perpetuate the false narrative that Wilson was properly trained. That's two. It evidences that Wachusett did that for its own perceived benefit, to try to settle the case without taking responsibility for the fraud, and instead of admitting 100% responsibility for the accident, asserting contributory negligence in the hope of a better chance of a lower settlement. And finally, it establishes that the lawyers were implicated in the fraudulent scheme at that point.
In the court's decision in footnote 4, it says that although the appeals court decision discussed the Wachusett's duty to keep employment records, plaintiff has not pursued any argument related to this issue on remand. Do you agree with that?
Well, I don't entirely agree with it. I agree that that Wachusett possessed the Shepard employment records before the deposition. That they didn't produce the employment records before the deposition. That after the deposition and after Shepard produced his employment records with Wachusett, they then located their own employment records for Shepard and produced them to their attorneys. And their attorneys did not produce them to plaintiff's counsel in the case until after they waived the attorney-client privilege. And so I don't completely agree with it. I do agree that the judges, as I said, that the judges finding that Wachusett did not know about the fraud before Feely testified is entitled to deference.
So when they realized they hadn't produced the employment records that they did have in their possession, they still didn't turn them over?
They sent them to their lawyers. And then the trail ends. And the lawyers did not send them to plaintiff's counsel.
So,
Okay, go ahead. We're over time, but go ahead.
So the essence of, I just want to make sure I understand this, the essence of what you're saying, the fraud on the court then is not disclosing fully the scope of what happened.
Well, the essence...
And using that non-disclosure to get an edge during negotiations to resolve the case, or during mediation. Is that the essence of the fraud?
That's the essence, and I would just add one other thing, that, and I recur to this because it's black letter law, and it goes to the core of what the judge's clear error was, which is that they didn't timely respond in any way, shape, or form for a full year after they learned of it. And during that time, they tried to benefit from it. That's the essence of it.
Okay.
Thank you.
What's the record citation that they did not produce the employment records they did have in their possession until the waiver of the attorney-client privilege?
The record citation is in the and I don't have it at my fingertips, Your Honor, but it is in the certified transcript in which I declare in open court that they did not disclose, I did not receive those records.
And did they respond to you?
They did not respond. They did not deny that. Their lawyers did not deny that.
Thank you.
Thank you.
All right.
Good afternoon, Your Honors. Douglas Radigan for the appellee, Wachusett Mountain Ski Area, Inc. Your Honor, if I may start with your last question, which is a little bit unusual, but I want this court to understand what the record is with respect to the employment records, because this is a red herring. Now, there is no question that at the time of Jacob Shepard's deposition, that counsel failed to produce the records as part of a 30B6 notice. Notably, although discovery, overlooking discovery is not excusable, it would be something that should be addressed as a Rule 37 motion. But part of the reason, Your Honors, as to why Wachusett chose tactically to waive attorney-client privilege here is because of the very strict standard of what is fraud on the court. What the record evidence...
I want to go back to when they realized that they did not produce those documents in response to discovery before the 30B6, they had a duty to produce them immediately without any motion practice or anything else, right?
I don't disagree with that, Your Honor.
I want to know if you agree with it. This is not the time to fool around with language.
I understand. Specifically, that notice was 23 topics and 31 additional requests for document requests.
It was employment records for the person the username who allegedly took the training. He's got an uphill battle until we got to this moment, at least in my opinion. So I want to be crystal clear about this.
And I want to be crystal clear with my response, Your Honor, because the record does show that counsel did not make an inquiry. It was inadvertent, Your Honor, but counsel did not make an inquiry to Wachusett for records with respect to Jay Shepard. We've produced email communications as part of our waiver of privilege between counsel and Wachusett, which show that the process to gather documents responsive to the number of topics as well as the document requests. Those record sites, Your Honor, are in the third appendix, in particular 120 as well as 216. There are also other references, Your Honor, 230, same third appendix, 232. What those, Your Honor, show is that the custom and practice of gathering documents responsive to this and other discovery requests was, in effect, counsel would reach out to the person appointed at Wachusett to help aid with the process of gathering responsive documents. He did, in fact, do that, and counsel did not forward at that time the 30B6 notice himself. Instead, Your Honor, what counsel did inadvertently was he identified what specific documents that they needed and whom they needed it from. Regrettably, Jay Shepard was overlooked with respect to an area of focus that Wachusett was directed to look for. Mr. Shepard showed up at his deposition, as the appellant knows, and produced records with respect to his employment at Wachusett. Now, Your Honor, when that was reported, as the record shows from the sites, Wachusett promptly provided those records to their counsel. But at that point, Your Honor, the only...
Appendix 3, 120, and 216?
120, 216, and 232 are the...
Okay.
And 163 is the communication from Wachusett's agent asking after the deposition, please make a deep dive. Now, there's a difference here, Your Honor, with respect to the records that have been conflated. Mr. Shepard, his involvement in discovery in this matter was tied solely to whether or not he did, in fact, work at Wachusett. There is not a request here in that request in the 30B6 for payroll records. It's employment records. So we did produce to counsel evidence that evidenced his employment. This, of course, is after the deposition of Jacob Shepard. And at that point, Your Honors, that point was already made, and it was no longer a relevant issue.
Is this happening before Wachusett tried to concede liability?
It is not, Your Honor.
Okay.
And this is also happening, Your Honor, at a time prior, as the trial court had found, that Wachusett knew that there was something amiss. As had been conceded in HACHE 1 in the appellant's briefs, the explanation that was provided by Mr. Feely was a credible one at that point in time. So this is a point in time, Your Honors, in which it is not yet known, as found by the trial court, that there was anything amiss with respect to these records. Yes, counsel did not look for those records or direct their client to look for it. It's sloppy. It is something that was a discovery issue that ultimately was cured by the fact that that deposition went forward, and the dates of employment, which were the only issue that were an issue with respect to Jay Shepard, were confirmed at that deposition. Now, with respect to the question as to whether ratification is an appropriate argument, I'd like to turn to that.
Before we get to this idea, basically his argument is that 1 year cannot possibly be timely. And there's some appeal to that argument.
Well, Your Honor, respectfully, the court specifically found that between September 2017 and October 2018, when this occurred, there was no substantive work with respect to what was going on in this case. The matter was teed up for a later mediation. The trial was put off. There was no further discovery. And with respect to fraud on the court, Your Honor, the standard is clear that we're here to protect the court from that information. He's conflating the purposes of a 30B6 designee. That is not testimony that's before the court. And in fact, Wachusett closely followed, as we've cited in our memorandum, the Hazard Treaty, which talks about what should happen in these exceptional and extraordinary circumstances. And I would contend, Your Honor, that what was done was absolutely appropriate. Any efforts that appellants took in an effort to take trial testimony or anything to that nature were all done for the purposes of using this evidence that he knew for 2 years at a time that actually dates before Wachusett learning it, and intending to use it for inflammatory purposes for trial. There's no question that that time passed, but there's also no question, as this court found, that no steps were affirmatively moving forward in this case, and nothing was going to happen other than a mediation that the parties had already planned.
Well, let me ask you about that. So if this goes back to the issue of whether it's a fraud on the court. So if you have a party that is aware of an issue with discovery under court rules, and there is a delay in rectifying that, and it tends to hamper the other party's ability to uncover evidence, and then in the course of all of that, you're engaging in mediation, naturally in the hopes of suppressing the numbers for a resolution of the case, doesn't that tend to make it more of a fraud on the court?
Your Honor, it's important in terms of the timeline that's been found here. At the time that the fraud was uncovered by Wachusett, as been found by this trial court, that was in September of 2017. At that point in time, Your Honor, all discovery, other than a motion for an independent medical examination, which goes to damages, had been completed. So there was no furtherance of a scheme with respect to this. Now, I would also suggest, Your Honor—
But Wachusett did not uncover the fraud, right? I mean, I thought plaintiff's counsel uncovered the fraud and Wachusett's—
Wachusett, Your Honor, as they were sitting through the depositions, as Mr. Shepard gets deposed, as these
I'm sure this was a bad day for the attorney for Wachusett.
This was something that was evolving. What's clear here, Your Honor, is the plaintiff had not only his day in court once, but multiple times. And this second time was after an evidentiary hearing in which the plaintiff had the opportunity to take discovery, where Wachusett took the extraordinary step of waiving attorney-client privilege for the sole purpose, Your Honor, of showing that Wachusett had no sentient knowledge of any fraud or participated in any active engagement here.
Well,
now,
it also went to the whole advice of counsel defense too, right? Didn't it tend to give some force to that defense when you're saying, okay, we'll open up the books and we'll show you?
Your Honor, that is important for a couple reasons, because my brother raises, although hasn't been previously raised, and I would contend it's not before this court, the idea of ratification. Now, ratification is something that is a contractual argument that happens in the context of business. Now, what's happening here, Your Honor, is something that's different than in the context of business. This is happening in the context of litigation. And it is appropriate, Your Honor, since it is occurring in the context of litigation, for Wachusett to rely upon its attorney as an officer of the court to take any appropriate actions that he or she deems necessary to correct this. And nobody's contending from Wachusett that what was done here is not, it was a difficult situation for Attorney Sweet. It was, I'm sure, a very difficult thing to manage in terms of what the responsibilities are. But it's very clear that under the Hazard Treaty, which is a treatise that is well respected here, that Attorney Sweet did exactly that. He did his, yes, we went to mediation. That mediation memorandum is not fraud on the court. It's not before the court.
Did it say this guy, the lift operator, took the online training?
I don't know that off the hand, Your Honor, but I will address that mediation memorandum was something that was produced because we've waived attorney-client privilege. It was a work product of counsel, and it was produced to the mediator after, and then later produced to the client. Now, at that point, there is no fraud because plaintiff already knows that, in fact, that these misdeeds were done, and they are looking for an opportunity to present that evidence at a jury trial.
So, but there's potential, whatever word you want to use, fraud on the mediator.
Well, that's
There's potential to mislead the mediator, right?
Your Honor, I think what was represented was that, and this is in fact true, the individual involved with Dylan Wilson, he did receive the hands-on training. There's no question about that. He did not receive the bullwheel training. Bullwheel training is something that is only recognized in a handful of...
We understand the distinction between properly trained and whether he got the bullwheel train.
But, Your Honor, there was no settlement. Plaintiff went to the mediation, defendant went to the mediation. They were both armed with full knowledge of what this evidence showed. What's important here is that the plaintiff was given an opportunity to present its case, its claims, without being tainted in any capacity at all in front of the trial court when it presented a case on damages only, losing comparative negligence. Now, you had asked earlier, and Justice Hodgens, with respect to the timing of this, plaintiff arguably should have brought, since they had knowledge prior to this to the attention of the court. They should have sought sanctions under a discovery motion. They chose not to do that. They chose to lie in wait in the hopes of using this inflammatory evidence. The reason this took as long as it did was because every effort that Wachusett's counsel made after the failed mediation for the purposes of stipulating the liability to make sure that the court was not impacted by this false evidence was met with resistance. It was in fact when the first instance that Wachusett tried to stipulate the liability that it was raised for the first time, this issue as to a fraud on the court. So, Your Honor, this is not a circumstance in which, there was an active scheme or deliberateness or involvement of the parties in perpetuating a scheme, which is active involvement, the scientia of knowledge that puts it into motion. What was happening, Your Honor, is that this was a very difficult circumstance with respect to something that wasn't known by Mr. Crowley as found by the trial court. It wasn't known by Wachusett and was in fact known to the plaintiff prior to this ever occurring.
So Wachusett learns of Feely fraud, falsifying these records, right? At a particular point in time.
Yes, Your Honor.
How long was it before Wachusett did anything to disavow that? Was it a year?
Your Honor, the first steps that they took, because we waived privilege, was to meet with the impacted employee. And Your Honors can see as part of the record, yes, and as part of the record, they met with him. Wachusett took affirmative steps to bring other people involved in the training program, and they relied upon the advice of their counsel. In the context of this case, Your Honor, discovery was complete. The parties had a mediation. It was after the failed mediation that Wachusett tried on multiple occasions to stipulate the liability to prevent this evidence from going forward.
Was it a year?
It was a year, Your Honor.
How long did they wait before they met with Feely?
Your Honor, I think it was upon learning of it, they immediately met with him. I see my time is up. If Your Honors don't have any other further questions.
Seeing none, the matter is submitted. And that concludes our session today. I want to thank the court officers and our staff for their assistance.
Court, all rise.